Yes.
So, my lord,
Prior to listing, if any, please give it to the court master.
no, my lord, this item 24,
Yes.
I pray for upgradation, my lord.
Twenty-four is a motion matter.
Motion matter, but upgradation.
Motion will take it up. Don't worry.
And my lord, I have another prayer. 7 and 21 may kindly be taken in on another day. my lord.
7 and 21.
Yes.
Okay. Seven and 21, both sides are represented. List after ensuing, held in list after 2 weeks as paid for by the counsel for the petitioner. Yes.
All right.
Please, your lordship. So I have to mention item number 1, the learned counsel I Hussain is out of station.
Okay.
And my lord, one more prayer, item number 4, my senior some personal problem, my lord. The rest is the short. So matter may adjourn for the day, my lord. 1 and 4.
1 and 4. Okay. Both same order, both sides represented.
Obliged.
Okay.
Please, Your Worship. Your Worship, I have to mention one repetition for listing, Your Worship. That is all.
This thing I just told you, please give it to the court master.
Upgraded item 23.
Please, Your Worship.
What is
My lord,
this
here
IA
this
for?
case will plead for extension of time for appearance, my lord.
What is the
Earlier
reason?
for- My lord,
What is the reason for not?
my lord,
able to appear?
order was passed on 31st/7 and we could obtain on 5/8. My lord, he could not collect the bailer, my lord, and immediately he could not appear. He appeared on
Okay,
8
we are
days,
extending time. 10 days from today.
my lord.
Mr. A.R. Sigdar, learned counsel for the applicant, submits that due to reasons beyond the control of the applicant, he could not collect the certified copy of the order dated 31/7/2024 passed by this court in the connected WPC 3751 of 2024, and also could not arrange for a bailer. And accordingly, he could not appear before the Superintendent of Police within bracket border, bracket close Bopeta, within the time allowed, and take bail. Next paragraph. Standing counsel for the Home Department. Miss and Bedi, learned counsel appearing on behalf of Ms. P. Barua, learned standing counsel for the respondent number 6, and Mr. P. Sharma, learned government advocate, appearing for the respondent number 3, are present. The learned standing counsel for the Home Department opposes the prayer. On the ground that there was a delay on part of the applicant to appear and take bail. Next para, either as it may. The explanation tendered is accepted as good sufficient cause for the applicant for not being able to appear before the concerned authority and take bail. Accordingly, further 10 days time is extended from today for the petitioner to appear before the Superintendent of Police within bracket border, bracket close Bopeta, and take bail. as per the directions contained in the order dated 31/7/2024, passed in connection with WBC number 3751 of 2024, on the same terms and conditions as contained therein. Next, this order shall be read together with order dated 31/7/2024, passed in WBC 3751 of 2024.
Ably obliged.
Any discussion?
Upgraded item 25.
May I please, Your Lordship? Lordship, this I has been filed for extension of time, Your Lordship. The petitioner is already on interim bail. It is on earlier occasion, Your Lordship. The matter was listed on 27/5/2024. Your Lordship, then this Honorable Court directed the petitioner to appear before SP Border Bongaigaon on 18/6/2024. But it is on our part of negligence, Your Lordship. We forgot to communicate same to the petitioner, Your Lordship, and the date has expired, Your Lordship.
हाँ ठीक है सर. You see, there's difficulty in accepting your explanation in this matter. You forgot, that is okay, but please come to page 8. This is still not a certified copy of the order. Therefore, intention to comply with the order was never there. You'll have to appear before the Superintendent of Police and get bail. For that, you need a certified copy. You never applied for a certified copy, never obtained it.
Lordship, it is on our part of the negligence, Your Lordship. We totally.
That is the most difficult part. For a lawyer to forget, having taken bail to forget to communicate, is really not acceptable. Any other explanation could have been good.
For that reason, the petitioner should not suffer. He is already on interim. But
No, but one must suffer. Either the lawyer will suffer or the petitioner will suffer. What do you want? The petitioner got bail and then it doesn't come. Why should the lawyer take up the blame? It is not a case where lawyer should take a blame.
Lordship may fix up this matter for hearing, not allowing the IA Lordship. It's a 2019 matter, Lordship. Otherwise, again, it will not be listed for another year or so, Lordship.
Lordship may take up, but take
There
up
was
the
a-
matter on Monday.
There was a movie where the two friends always did something after a toss. So what is the quantification of sufferance? How would you quantify it? You've seen how vehemently Ms. Rama is opposing.
Since it's an old matter, Lordship, it is.
Yes,
and
okay, but
the
very,
writ petition has been
The
filed
lawyers-
in 19, Lordship. The opinion must have been of a very long
Lawyer-
time before.
lawyer is taking up the blame. That's the difficult part. How much? 5,000? Or we were wrong, we should increase it.
10,000 should be the minimum cost so that next time this
No, you see, the lawyer is taking up the blame to impose a cost on lawyer also, it pinches us. But your smile shows that 5,000 is very less. Okay, we give a cost. So next time we will not forget. Heard Miss
FN Jaman.
FN Zaman, Learned Counsel, appearing on behalf of the of Mrs. R. Chaudhary, Learned Counsel for the applicant on record. Next paragraph. By an order dated 27/5/2024, passed by this court in connection with 6/1 of 2019, the applicant, who is the writ petitioner in this writ petition, was granted bail with a direction to appear before the Superintendent of Police within bracket border, bracket was Bongaigaon, on or before 18/6/2024, with and comply with the other conditions attached thereto. Full stop. By filing this next paragraph, by filing this interlocutory application, the applicant, the learned counsel for the applicant has submitted that she had forgotten to communicate the said order dated 27/5/2024 to the applicant. And it is only during the last puja vacation that she remembered the order dated 27/5/2024. And by the time by then, the time allowed for appearing before this place with the bracket order, and to take bail had expired. Next para. Miss N. Betty Leonard, counsel appearing on behalf of the Miss P. Barwa, standing counsel for the Election Commission of India, and Mr. P. Sharma, Leonard, government advocate, are present. Next para. Ms. A. Verma, Leonard, standing counsel for the Home Department, opposes the prayer on the ground that the reason assigned is too vague and unacceptable.
Lordship may even,
Full stop. She also submits that instead of granting bail to the petitioner, the matter be heard expeditiously, as any further delay would not be in the interest of justice. Next paragraph. Be that as it may, as the learned counsel for the applicant is taking up the responsibility of committing a mistake of forgetting about the order, the court is of the opinion that the prayer made in this application be allowed at a cost. Next paragraph. Accordingly, while directing the petitioner to hand of the gore, the learned counsel for the
okay,
petitioner to, sorry, I here, it could be applicant to deposit the cost of rupees 5,000 to the Guwahati High Court Legal Aid Committee within a period of a week from today. That's all. Next paragraph. Subject to deposit of such cost within the time allowed, the court is inclined to extend the period of appearing before the period for the petitioner to appear before the Superintendent of Police within bracket border, Bongaigaon, in terms of order dated 27/5/2024, passed in the connected WPC 6/1 of 2019, and to take bail in terms of the said order. Which shall be done within an outer limit of 10 days. Within an outer period of 8/11/2024. Next paragraph. It will make clear that on non-production of the acknowledgement of deposit of cost may entail recalling of the order passed today. Next paragraph. All the other conditions contained in the order dated 27/5/2024, passed in WPC 6/1 of 2019, shall continue to apply. Next paragraph. This order shall be read together with said order dated 27/5/2024, passed in WPC 6/1 of 2019. If, this application stands disposed of.
Lordship, when IAs are filed for extension of time, it would be better if certified copies are provided. Like in the previous matter of Mr. Sigdar, there's a certified copy. And copies like these do not add to what they are submitting. The submission and the
That's why we,
yes,
that's why,
Lordship may make a observation, Lordship, so that next time when they file IS for extension of time, only certified copies are placed before this court.
we will think over. We'll think over.
This is a suggestion, Lordship.
That's okay. We'll think over.
From the proposal.
The, there is another flip side to it. Because if a certified copy is presented in the interlocutory application, then for the purpose of the bail, again, they will have to obtain a second certified copy. It multiplies some cost.
Some cost, Lordship, but at the same time, here the order was passed sometime in the month of March.
We understand. That is why you see we had been in this
I
particular case,
understood, Lordship, and
because otherwise we don't know what is happening. We
to substantiate
break-
their submissions, Lordship, if it's a certified copy, we know that exactly they did take the certified copy, but they failed to send it across.
no, we understand that. That's why we had to take the brunt of the cost. But to
But you-
impose certain conditions, we are also thinking of the part that there may be some people who may be burdened with the cost. That's, we think over it. We have taken your suggestion. We'll think over it.
No problem.
I dispose.
26.
My lord, in this case, I filed Ugalatama. That was not.
Pardon me. I did not get it. Please repeat again.
In this case, I newly engaged, I filed Ugalatama, but
Okay.
that was not, my name has not reflected, my lord. In this case, the petitioner taken into custody. And this
This is for bail.
Yes, my lord.
Then we'll take it up after the motions. Because extension of time we have taken up, but if it is for bail, we'll have to go through the records. We'll take it up after Sabari, after the motions are. Or can we issue a notice? We'll take it up
Issue notice.
Wednesday then,
Yes, Lordship.
next. When 6th, we take it up then.
Yes, Lordship.
Okay. But Mr. J. Ahmed, learned counsel for the applicant,
Copy 19.
issue notice on this interlocutory application by which the applicant is seeking bail on being taken into custody. Ms. A. Verma, learned standing counsel for the Home Department, Mr. Ms. N. Bedi, learned counsel appearing on behalf of Ms. P. Verma, standing counsel for the Election Commission of India, and Mr. P. Sharma, learned government advocate, accepts notice on behalf of the respondents. Stop. Requisite extra copies of this interrogatory application be served on them in course of the day. Next para,
Extra
list
petition.
on 6/11/2024. 6 is sufficient?
Yes, Lordship.
Lord, my name may be reflected in the court.
Do consultation.
If your Vakaratnama comes, they will do it.
We will orders for them.
And Mr. Devan,
Lordship.
if his name is not shown, tell him. You have something, very strong thing in your hands. Earlier, police used to keep baton. You have those things with you now. You threaten him if names are not shown.
Item 2 for motion.
May I please, your lordships. My lord, the petitioner's grandfather's name is Kadir Byapari, my lord, and father's name Rohim Boksho, my lord, whose name appeared in the 1951 NRC, my lord, along with other family members, including petitioner's mother name. And then her father's name appeared my lord, 1951, my lord, kindly say, NRC page 16, my lord.
NRC, you know the law well settled by this court.
Yes, my lord. Then, my
Any
lord,
other document to connect you with your projected parents?
then, my lord, parents, my lord, only record, my lord, my father's name with my name, my lord, has been reflected. That is, my lord, PAN card, my
No, you
lord,
see, you are disbelieved because of the fact that you gave witness of one brother.
brother, my lord, elder brother.
Somewhere I read it that he gave the addresses wrongly.
No, that is not reflected in the judgment, my lord. So far I have gone through. That issue is not, my lord.
No, yes, it was there. His place of birth gave somewhere else.
Yes, my lord.
Fathers were resident of somewhere else. So that is something which is a missing link.
My lord, in
When
the
parents are residents of A, child cannot be born at Z.
shifting
No,
issue
we
is
understand
there, my
that.
lord.
But you see, then there must be something which is very convincing.
My lord. Actually,
Because
my lord,
if a person who says that I was born in the place different
Yes,
from the place where the parents reside,
yes, sir. I have said that, my lord, I was born and brought up at the village Bogdor, my lord, and I was born in the year 1957. Earlier, my lord, our forefathers, my lord, were originally residents of village Reservoir. And in the year 1955, my lord, father had shifted to village Bogdor, my lord. However, we have shifted, my lord. All the villages to and from are within the jurisdiction of same police station, my lord. District same police station, my lord. Just little difference, my lord. Distance is very small, my lord. And that shifting issue is there, my lord.
but you see, the difficulty is, you see, there is a witness who
My lord.
says, who gives a statement. Let us say that statement is A. Now, in exercise of writ jurisdiction, are we permitted to read the evidence as B? Then,
What happened, my lord? My elder
because you are
brother,
trying to explain in your writ petition that your brother deposed, he did not remember and he deposed wrongly. That is something.
I have stated in paragraph 11, my lord. Actually, what happened? My elder brother is 70 years old, my lord. That at that time in the year 2018, my lord. And my lord, I thought, my lord, this question, my lord, was, my lord, directed to me, that as to where I was born, my lord. Actually, the question was taken for me, my lord, and then I answered I was born at village Reservoir. That I have stated, my lord, in paragraph 11, my lord. Otherwise, my lord, I have a linkage with my father that is reflected in, my lord, PAN card, my lord, page 29. And with the name of my brother, father's name Rohim Boksho is there, my lord. So I think, my lord, I had been able to establish my linkage, my lord, with my father. Now,
Mr. Mola, there is a fundamental legal question which has come into fore. Number one, you see this petitioner is Asia Bibi, right?
Asia Bibi, my lord.
Yes. Now please tell me, the evidence of Z, who says gives a statement A in evidence cross-examination. Now, can Y come to court and say that this is that explanation given or that statement A given in court was wrong? Is he permitted? Is another person permitted to state on behalf of the witness that the witness understood wrongly, replied wrongly? Is it permissible?
That is not permissible, but that happened, my
No,
sometimes. 72 years old, my lord.
no.
My lord, I thought that the question was, my lord, directed
Well,
to me.
then follow the our great leaders in politics. Their wisdom starts after 70. And many politicians of 70, 80, 90,
My lord,
whose wisdom is
health consciousness is there, my lord. Illiterate person, my lord, they are now lasting up to 80, 85. But people in the village, my lord, losing at the age of 60.
take it up some other day because we are not convinced.
And I am not, my lord, on the bail, my lord. May I pray for bail, my lord?
Lordship may give a short date for hearing, Lordship. Since it's an old matter, if it goes, Lordship issues bail, it won't be listed sooner, Lordship. Hmm. Hmm. Early hearing can you break away sooner? Hmm. Hmm. Document to 9. Linkage to 9. Continuity. Person giving my color बोलेंगे तो भी continuity की तो बोलेंगे voters list की क्या सर 51 NRC renewal. That's in 1966.
My
single
lord,
voters
what
list.
has mainly been discussed in the impugned judgment, my lord, is the true names of my husband. Actually, my husband's name is Basiruddin. That is in Assamese, my lord, that is correct.
17. Again. 71 94. Like the explanation line. 94, her name appears. He is 38. No.
The petitioner, Ms. A. Verma, and is standing counsel for the Home Department. Mr. Puli Lanel, counsel appearing on behalf of Mr. A.I. Ali, standing counsel for the Election Commission of India, and Mr. P. Sharma, Lanel, government advocate appearing for the respondent number 4. Next para. The records as called for is received. Accordingly, list the matter. Again, after is the matter on 25/11/2024. Next, in the meanwhile, if the petitioner has not already been arrested and taken into custody. No, if not deported, by now, comma shall not be deported without
25.
further orders of the court. Next list on 25/11/2024.
3 to 8 June.
Deeply obliged.
Minor, 3 to like.
Item 3.
Maybe.
अगर आपने एक्स्ट्रा कॉपी ऐसे होती है
There is another direction was given not by the Sound Court to produce the voter list of 1997. What is that is the order last for existing year. Now, it was listed in the motion column, and notice of motion is and bail was granted. I appeared there.
Mr. Rashid, in your writ petition,
Well,
you have not even made any statement as to what was wrong in the appreciation. You merely say that the exhibits written statement and evidence was not read in proper perspective. Now, how do you understand what you intend to convey?
that probably your Rashid right. The problem is judgment itself is, and the main point in that that my name appeared with my mother, and also my mother also deposed.
Because there's a long gap. After 1966 and 70, you are producing a voters list of 1985. Thereafter, you jump to 1997. And
My-
then 2005. There are a lot of gap in between.
My Gavin here. Actually, there was one shifting lot and shifting. Same names are not appearing in their name list. Sometimes. And due to that is due to earlier there not.
But apart from the voter list, how do you connect yourself to your projected parents?
First, my parents voter list that is kindly say 1966 is 28.
Page
28
28. 22 is a voter list.
My lord, 66. Name of my father and mother. And there is a village, you can see village secretary part 1. Under LC Miller of Ivory, number 42. And 670 Miller, LSC 42 of Ivory, and village secretary. And only name of my father and mother is there. And 1985, 15 years gap Miller, Miller is rightly Miller. Annexure 7, name of my father, mother, and my name Miller. And I was the first voter Miller 1985. 21 years. Page 13 Miller. This time also Miller, village is same. Subsequently Miller, they are the Miller. 97 also Miller, same village. And in the same Miller, father was not there, mother is only myself and wife Miller.
You're taking about admission after 2 weeks. All sides are duly represented. Issue notice. Returnable in 2 weeks without requiring the petitioner to take first steps. Next, list in the admission column on 27/11/2024. You're on bail.
I, Miller, I have granted bail, Miller. I appeared there on 12/10/2018. And in between, Miller, 28/11/18, there is an order, Miller, to continue again.
Okay.
Or bail will continue.
Mr. Sharma, Mr. Verma, go through the records of this matter.
We want a copy of the petition. Copy will be making it. Sorry, sugar.
Item 4,
Adjournment has
Four has
It's
been
adjourned.
adjourned, Lordship.
for adjourn.
I took you now. I go 9.
Item 5,
You have seen the records?
Item 5, Lordship.
Huh.
Earlier I have seen it.
Okay. Which page is the opinion?
Opinion is at page, my lord.
Page
Page 22, my lord.
22.
Yes, my
Now this previous opinion of the IMDT is rendered against whom?
Before passing this order, my lord, against his brother, my lord, Situ Das, he has been
Huh?
declared to be a not foreigner, my lord.
Who?
Situ Das, my lord, the petitioner's elder brother, my lord. This is at page, my lord. 17. Situ Das. Page 17 starts, my lord, I want to know.
This document was not exhibited by you.
No, my lord. Thereafter, my lord, the petitioner's wife also, my lord. The petitioner's two cases has been registered, my lord, against the petitioner and one against her, against his wife, my lord. Wife has been declared to be a not foreigner, my lord. Wife, my lord. Declared to be Indian. Yes, my lord.
No, wife must have his father.
From perusal of the records, from perusal of the records, my lord, it is seen that the petitioner as well as his family, my lord, are seen in India, my lord, right from 1964, my lord. Kindly see the page 32, my lord. The certificate has been issued, my lord, by the superintendent of home, Bhavanigaon, Kamrup, my lord. Page 32, my lord. Happy to certificate.
What were the records of the identity case? That will be available where? Page 1717. Where it will be available?
Immediately, Gwalpara, my lord. Immediately, Gwalpara.
Lordship, I am dating Walpara is no
I'm
longer
dating-
there.
no longer-
Yes, but now he will be able to say this.
Pending matters may be available, renumbered as FT.
Yes, sir.
But matters which are disposed of,
Way back, my lord,
uh,
in 2002.
in 2002.
Yes.
Can you get information? We'll take it up next week.
Yes, Lord. Lordship, next Monday or any day, Lordship?
Next Monday, it will be Diwali. You will not be able to get it by then,
Yes, yes.
in 1 or 2 days.
Wednesday, Thursday.
Wednesday, 6th.
Yes, Lord.
6th of November.
Also, they represented. Mr. G. Sharma Lanet, standing for the Home Department, shall make an endeavor to obtain instructions as to where the records of case number 5962 oblique capital G oblique capital D oblique 01 arising out of ERO case number 327 oblique 122 oblique 36 decided by the illegal migrant within bracket determination bracket close tribunal comma Gwalpara by an opinion dated 7/10/2002 within bracket annexure C bracket close would be available.
No.
Next para. The learned counsel for the Mr. S. Islam, counsel for the petitioner shall provide a copy of the writ petition to the learned standing counsel for the Home Department to enable him to obtain instructions. Next paragraph. The learned standing counsel for the Home Department is permitted to send a downloaded copy of this order to the concerned authorities to obtain instructions. Next paragraph, based on 6/11/2024. Give him a copy.
Yes, Lord.
Item 6,
The impugned order is dated 30/8/2018, my lord, page number 73. My lord.
Just a minute. Item 6.
Item 6. Petitioner, my lord, is the daughter of one Mansur Ali, my lord, Mansur Ali alias Mansur Ali Bepari, my lord. His name appears in the NRC 1951, my lord. And in the inquiry report also, my lord, is that has been indicated, my lord. And in the inquiry report, the petitioner's father's name is written as Mansur Ali, my lord. Interestingly, my lord, her husband's name has been wrongly inserted in the inquiry report, my lord. Late Pasimati, my lord. In fact, my lord, her husband is on Shahalom. He is still alive, my lord. And that has been corrected by the Whitener also, my lord. Kindly see the inquiry report, my lord.
My lord, WPC 3917 of 2016, Lordship, Rupali Bibi versus Union of India, where it was held that mentioning the name of the proceedee as son or daughter in the notice by the tribunal is no proof of such relationship, Lordship.
In
It
fact,
is
my lord,
no
the-
evidence of such linkage, Lordship.
In fact, the LVO, my lord, never visited the house of the petitioner, my lord. Kindly see the statement of the suspected person, my lord, the petitioner, my lord, which is at page 50, my lord. Managula copy, my lord. The petitioner, my lord, is said to have stated against herself, my lord. And her signature is not, my lord, there.
Report for LBI 2.
WS. You have not been able to establish the link with your father. No link with your father.
If Kabinnama is there, my lord. We should
Kabinnama
get my lord 40, my lord. 40, my
Not-
lord, of the record, my lord.
Not proved. Not proved.
Her brother has been examined, my lord, as GW2, my lord. And his name appears in the
And
total list, my
your
lord.
exhibit G loses its evidentiary value.
Marriage certificate is Kabinnama.
Yeah, marriage certificate, Kabinnama also, my lord. Marriage certificate is there, my lord.
Kabinnama is, but was it produced before the court? What is it? Exhibit?
It was marriage certificate, but it isn't.
Is marriage certificate and Kabinnama one and the same?
No, my lord.
Two different
Two
documents?
different, my lord. Marriage officer has issued the certificate of marriage certificate.
We
and
know
Kabinnama-
that. We are asking you, before the tribunal, did you produce two different documents or one document?
Different documents, my lord.
Show us from the order.
Order, my lord, it is. That I have to take instruction, my lord.
No, there is a marriage certificate, there is no Kabinnama.
Yes, my lord. Kabinnama is also there, my lord. Page 40, my lord, of the record, my lord.
Page,
Page 40, my lord.
40.
40, my lord, of the record.
that was not proved. That is not an exhibited document.
No, my lord.
Your exhibit document is exhibit G. That is a marriage certificate.
Marriage certificate.
Do you have the, you come to page 74 of your writ petition?
Yes, lord. Judgment.
Yes, opinion, para 5.
Para 5, my lord.
So these are the exhibits. Kabinnama is not shown as one of the exhibits.
And maybe the Xerox copy maybe might have been
No, no,
submitted, my lord.
there may be hundreds of documents, but we are not
Yes,
required to read documents which are not exhibited.
yes.
And your marriage certificate was not proved by calling the Qazi.
That
Then
may be
there is
fault
no
by
link
the
at all.
conducting advocate, my lord.
Hmm?
That may be a fault made by the conducting advocate, by the law court, my lord.
No, whoever has done it, we are not on that. The question is that when we are examining the records,
Yes.
we don't find your name could be connected to your projected parents.
Yes. Otherwise, my lord, in the inquiry report itself, my lord, indicates that the petitioner is the daughter of on Mansur Ali, my lord.
Those things you
Whose
are
name
aware.
appears in the voter, in the
Mr.
NRC
Islam,
1951, my lord.
You are aware of the case laws.
Yes, my lord. Only see the page 14 and 15 of the report, my lord.
No, but you are aware of the case laws.
Yes.
Then after that, what is the purpose of reading that document? We accept your statement,
Yes.
but then how does it help you?
My statement, my lord, it shows in the record, my lord.
Hmm?
It shows in the record, my lord. The inquiry reporters, inquiry officers report. my lord.
You have definitely understood what we are trying to say.
Yes, my lord.
Then respond to that query.
So, my lord, let the matter be fixed for hearing, my lord.
We are hearing it.
Yes, my lord.
What do you think we were doing? We are doing it. On the record, we are not finding any document to connect you to your projected parents. See, this investigation by the for the purpose of initial inquiry
Yes, sir.
must be read as a whole. This cannot be read in part, even if it contains the name of your father.
Yes.
But the fact is that that you have entered into the country illegally. That is also a part of that investigation.
Yes, my lord.
We can't accept one and
And in
reject
the
one.
statement of the petition, my lord, her signature is not there, my lord. Kindly see the statement of the petitioner, my lord, which is a page, my lord. 50, my lord. She has stated against herself, my lord. May I read, my lord? If she stated against herself, my lord, she admitted before the LVO, my lord, that she has illegally entered into India through the Dhubri border, my lord. Then, my lord, what is the necessity to Registered a case, my lord. She must have been arrested at that very moment, my lord. Once she admitted before the LBO that I am a Bangladeshi national, my lord.
Do you really want a comment on that? Then
From perusal of this record, my lord, it is presumed that
you see,
no inquiry is
you
made
you are
against.
a learned counsel.
Yes, my lord.
Now please tell me that, let us say in today evening, there is a theft in your house and you caught the thief. Then according to you, what should be done? No arrest.
Yes, my lord. At least, my lord, I have stated before the LBO, my lord. My signature must have been there, my lord.
No, even in the tribunal, you could have dispelled that. That is
Yes.
not done.
This was a part of record, my lord. The landed tribunal, my lord, should have considered this also, my lord. And two independent witnesses, my lord. They also stated.
You see, can a
same line.
statement of anyone, you show us the law.
They were
that-
also not examined, my
no,
lord.
You show us any law by which a statement made by anyone
Yes.
becomes a proof of
On the basis of this
proof
statement,
of-
as well as the
proof of
statement of the
parentage.
private respondents, my lord, the instant case has been registered, my lord.
Statement made by you, recorded by the
LBO.
recorded in the this verification report cannot
Yes.
become a proof of parentage.
Yes. A statement of the respondent number 8 and 9 also, my lord.
You see, those arguments doesn't take us anywhere.
Yes.
You know the reason why?
This is part of record, my lord.
No.
The
Let me
learned
show you
tribunal
why.
should have considered
You
this
have a
also.
copy of your writ petition.
Yes, my lord.
You come to your in this writ petition. Please come to page 17.
Yes, evidently.
Correct.
Yes.
Now here you have said Miss So and So, Musama so and so,
Yes.
aged 57 years, so and so.
Yes.
Correct.
Yes.
Now in your affidavit, have you sworn that the name you are stating above is correct? Look at it. Look at that affidavit. No affidavit says so.
Yes, my lord.
Therefore, please don't make those submissions where you would fail. Nobody gives a statement of I am so and so on oath, and therefore we have a provision in the CRPC
yes,
and
my lord.
IPC by which a person
Pardon is-
who's coming as an imposter can
Yes.
still be arrested.
Yes.
In these examinations, recruitment examinations, we always find some people or the other coming as an imposter, saying that I am A, son of B, and sitting in the examination and they are caught as imposters. Now, please tell me, mere holding of an admit card, does it make somebody a son of XYZ? It doesn't.
That is why my humble submission, my lord. Documents is there, my lord. Documents is there. She is an Indian citizen, my lord, and her parents'
How do you
name
connect? We
appeared
are
in the
asking
voter
you-
list of
we are asking
1966
you
and
again and
70, my lord,
again.
in the Indian voter list, my lord.
We are asking.
So, 66 and 70, my lord, also, my lord. Yes, my lord. Because, my lord, she has no direct link with her parents, my lord. That is the fault on her. Actually, my lord, in the Kabirnama, my lord, her name is there. Her parents' name is there, my lord.
Kabirnama
That
was
has not
never
been
produced.
examined. That has not been proved, my lord.
Kabirnama was
That is
never
her fault, my
executed.
lord.
Was never
Otherwise,
executed.
my lord, she is an Indian citizen, my lord. If, my lord, she
Mr.
has
Islam,
not.
repeating of the same thing doesn't help us.
Yes, my lord.
Correct.
Yes.
We have told you why Your Kabinama is not, it is your own statement that the Kabinama is not.
Given that opportunity may be given to the petitioner, my
No,
lord. She will,
we
she
can't
is
give
ready
that
to prove
opportunity.
that Kabinama, my lord.
We can't give that opportunity. You're-
Because
it's
of
not-
that fault, my lord, a person cannot be, my lord, declared to be a Bangladeshi national, my lord.
Whose fault?
Petitioner's fault, my lord. Petitioner's fault, my lord. That may be, and last opportunity may be given to her, my
To
lord.
give you an opportunity, we'll have to interfere with the order.
No, my
To
lord.
interfere with this order, we must arrive at a finding
Yes, my
that
lord.
it is a perverse
That
order,
is-
incorrect
That
order.
is true, my lord. Yes.
Then you show us the
Yes. That is why, my lord,
infirmity.
my submission before your lordship.
No,
my lord.
your submission has to be.
She has
direct.
she has
Your
documents. my lord.
submission-
She has documents.
No, your submission
she could
has
not
to
prove,
be,
my lord.
Mr. Counsel, your submission has to be in tune
Yes,
with the prayers made. You must make your submissions to
Yes.
point out the infirmity.
Yes.
If you want,
Only because of her fault, my lord, she could not improve the documents, my lord. Otherwise, she is having documents, my lord. So, my humble submission before your lordship, my lord, an opportunity may be given, my lord. She will prove this, my lord.
the order. You show us any precedent from wherever. If
And
you
that
have
too in-
any, if you are
Yes.
relying on any judgments to show that.
And that too in a writ petition where we are exercising certiorari jurisdiction.
I will satisfy your lordship, my lord.
What happens to the time spent from 11 till 12? If you give an opportunity,
Yes.
you see, we have 10 queries. Today we ask one, you take an adjournment. Next day it comes, we put the second query, you take an adjournment.
No, my lord. No,
Is that the manner you want us to proceed in the matter? You have an opportunity. We have so many judgments saying that in a certiorari jurisdiction, we can't give you an opportunity to improve the case. We are examining the correctness of the opinion.
Yes.
My brother is repeatedly asking you to please demonstrate that the opinion is wrong.
I will show.
Additional documents is something you are not even set up your case in your writ petition. So the parameters of the very old judgment of Muhammad Ibrahimuddin is not also laid down.
Next week or any other date, my lord.
Yes, Mr. Sharma.
Lordship, apparently, Lordship, there was no link, Lordship, with her projected parents, Lordship. And Lordship, only link certificate is issued by the one marriage register Kazi, Lordship. That was not proved, and that certificate was issued in the year of 2017, whereas Lordship, a marriage was solemnized in the year of 1981, Lordship.
That cannot be doubted if the document is there.
Yes, but there is no such document. Lordship.
There is no law which says that unless the certificate is not issued on the day of marriage, it is invalid. The only problem is that the Qazi did not come and prove it. That is the only wrong committed. So in that regard, the opinion is bad. To discard a certificate, you discard a certificate on the ground that the Qazi is not proved, we accept it. But to discard a certificate saying that the document was procured in 2018, that is something it's not acceptable.
His Lordship, after commencing of the trial, Lordship, it was created, Lordship.
No, don't use the word created.
You said, my lord.
Created would mean that it is your establishment. That means the government is
Yes.
facilitating false document.
Yes.
Office of the Qazi is a government
Yes,
office.
my lord. They are working under them.
So that means you are manufacturing documents. How can the government stand up and say that, no, we are facilitating creation of a false document? You say that statement on by filing an affidavit. Let your home department file an affidavit in the matter. Please say an oath Then we'll see how we'll deal with that. How much time you need to file an affidavit? Saying that the document is a procured document.
We are sharing copy.
Lordship.
You don't have a copy of the writ petition.
Lordship, still somewhere misplaced, Lordship. That's why, Lordship.
The good plan can be put it on some other.
Be prepared, we take
And-
it up some other day.
Yeah.
Be prepared.
You give him a copy.
Yes.
You give him one more copy
Yes.
today itself.
What says the representative? The
Nine.
Leonard standing counsel for the Home Department does not have.
The Tasmanian order is at least 57 lordship, annexure 17.
I give an order shuffle yesterday. What is your link document?
Link document lordship, link documents are voter list lordship, that is annexure 13 lordship.
You see, we find nothing in your writ petition to connect you to your projected parents, because in this voters list of 1966 and 71, the names are different. Satish Kumar and Satish Chandra Das.
So page 25 is also their certificate of registration lordship,
Page
25 lordship. Annexure 8 lordship.
Oh, very good.
Annexure 9, page 27.
Yes, ma'am, for my sister. Nine was. Actually. Next week. So like. Only one document is this one. One second.
Ms. Verma,
Yes, Lordship.
there is something which is very glaring. This. Come to page 58.
Yes, Lord.
Last line, 2 lines. Moreover, OPS stated in a written statement. So and so. Again, in our evidence, so and so has stated father obtained a citizenship certificate, which is exhibit B. Mr. Sharma is showing us that page 25 photocopy is at page 26.
Yes, Lordship.
Is the document.
1956 document.
Yes. Now, in regard to that, subject to correction, we don't see a finding on exhibit B.
Yes. Not been discussed, Lordship. Lordship, there is 2 lines in the third paragraph on the decisions and reason thereof. It is noted that in the voter list of 1968 Exhibit A, the age of Satish Kumar, son of so-and-so, is 37 years, and the voters list of 1971, the age of Satish Chandra Das is 51 years. There is a remarkable age difference of 10 years between Satish Kumar in Exhibit A and Satish Kumar in Exhibit B. She's referring to both the registration documents, Lordship. In Exhibit B, in 1956, when this registration certificate states he's 28 years. Either the documents belong to 2-3 different people because so much of age
No,
discrepancy.
nobody will part with the original document to give it to the tribunal.
Yes, Lordship.
Because, please come to page 31.
Lordship, if she is born in 65, then she could herself had the certificate, Lordship. I have not a copy, they were washed up. I have not known.
She does not have the birth certificate, so therefore she is contesting the matter. But if she produces, and then there's, you have seen on exhibit B, nothing is there.
Yes, Lordship.
It has to be remanded back then. They will have to examine it in light of exhibit B.
to appreciate the registration certificate, Lordship. Yes, Lordship can do that. It is just mentioned, but there's no discussion on it.
No, that's why we said it's clarity. We first allow you to take bail. Thereafter, we'll pass orders.
The petitioner did not agree.
Heard. Mr. S. J. Sharma, done it counsel for the petitioner. For Union of India, who's there? Mr. Das.
MS. MSK.
Ms. K. Fukan, done it CEC, appearing for respondent number 1. Ms. A. Verma, done it standing counsel for the Home Department, representing respondent number 2 and 6. 2, 6, and 7. Mr. M. Kulil, and counsel appearing on behalf of Mr. A. I. Ali, standing counsel for the respondent number 3, and Mr. P. Sharma, learned government advocate, appearing for respondent number 5. Next paragraph. Although the respondent number 4 is an establishment under the Home Department, but the state authorities have not yet issued instructions to their learned standing counsel for representing them most of accordingly. Now, There is no representation from the respondent number 4. Next paragraph.
Yes, sir.
Aggrieved by the opinion dated 7/7/2018, passed by the learned member, Foreigners Tribunal, 9th Borpeta, in FT 9th, within bracket BPT, bracket close, case number 108 of 2016, arising out of SP reference IM within bracket capital D, bracket close T, case number 3722 oblique, within bracket A, page 57,
File
comma, the present, comma, whereby the petitioner was wherein the reference was answered in the affirmative. Where the reference as to whether the petitioner is a illegal migrant was answered in the affirmative. The present writ petition has been filed under Article 226 of the Constitution of India. Next paragraph. Pursuant to the order passed earlier, the records of the learned tribunal has been requisitioned and the same is received. Next paragraph. We have observed that as per the record, the petitioner has examined herself as DW1 and has also examined her mother, her projected mother, as DW2, projected mother, right? As PW2, DW2. And the following documents were exhibited. Page 58. Next, out of the said exhibited documents, Exhibit B is approved in original copy of certificate of registration of the which is issued by the registration authority North Salmara Thana, Vehapuri on what is the date? 11 November 1956. 11 November 1956. It is 11 or 1. Page 26. What is the date? First November.
Oh, 1st November.
First November 1956. Bearing serial number 4233. Although, next paragraph, although the learned tribunal has referred to the said exhibit in internal page 4 of the impugn opinion. No, sorry, 3, page 3 of the impugn opinion. By referring to the document marked as Exhibit B, but this, but the learned member, Foreigners Tribunal 9th, Barpeta, does not discuss the evidentiary value of the said exhibited document. Although the document is a vital document for the petitioner and non discussion on the evidentiary value of the said exhibit has caused immense prejudice to the petitioner. Next one. Therefore, without any further examination of the correctness of the impugn opinion dated 7/7/2018, referred over. Court is of the considered opinion that once a document has been exhibited by the proceedee within bracket petitioner, it is incumbent on part of the said learned tribunal to discuss the said evidence and then to return a file, then to render an opinion. Therefore, if the court is inclined to interfere with the said opinion dated 7/7/2018, passed by the learned member, Foreigners Tribunal 9th Barpeta in so-and-so case number so-and-so, page 57. Resultantly, to enable the said learned tribunal to re-examine the evidence, specifically the exhibit B, the matter is remanded back to the said learned tribunal for a fresh opinion after examining all the exhibits on record. Next para. In the meanwhile, to ensure the appearance of the petitioner before the concerned learned tribunal, comma. We are inclined to direct the petitioner to appear before the Superintendent of Police within bracket border Barbeta and sorry, within 14 November, within 14/11/2024, and on the appearance of the petitioner, namely Basanti Day, before the said authority, comma, the said authority shall record the shall take the thumb impression of the the fingerprints of the petitioner and also the biometrics of the iris of the eyes and take all other particulars as may be necessary to ensure her appearance before the learned tribunal. Next paragraph.
673 SCMC
On the appearance of the petitioner before the Superintendent of Police with the bracket border, comma, the said authority, the office of the said authority shall issue a certificate to the petitioner about her appearance. Next paragraph. The petitioner shall appear before the Foreigners Tribunal 9th Corbetta on 27/11/2024 and by producing a certified copy of this order as well as the certificate of appearance before the Superintendent of Police within bracket border, Corbetta, one shall await further instructions from the said learned tribunal. Next paragraph. Let the records be returned back to the learned tribunal forthwith. Next paragraph. In the meanwhile, the learned standing counsel for the Home Department shall also send a downloaded copy of this order to the Superintendent of Police within bracket border. Opinion source is interfered with and set aside. Next paragraph. In the event the petitioner does not appear before the Superintendent of Police within bracket border or before the said learned tribunal, comma, this order shall lapse going to afflicts of time, lapse by afflicts of time. So there's a time limit given, and this order will evaporate. This is the only time we use in our homes that camphor, which has a tendency to evaporate. So we are using that camphor in our order.
Item 9.
May I please?
Yes.
We have filed an IA, seeking interim protection to the petitioner.
But Mr. Mondal, your beaming smile discloses that there is nothing in the case.
My lord, lordship will find the page 63 is the impugned order.
Page
63
63.
in writ petition, my lord.
I mean, you're not pressing the I press করবো I to 9 I to page 63 foot. You can change of address. No, district কি আছে?
বরপেটা
কিবা এটা গন্ডগোল হিসেবে ধুবড়ি পাইছো আমি। এই বাস আপনার কোনে পাই করেছে না?
What is your name?
my lord.
Suleiman Ali.
Suleiman Ali
What is the name of your father? Hussein.
Hussein.
But how do you connect this? There's no document to connect apart from Gambura certificate.
Now voter list is there, my lord.
Which one?
My lord,
Exhibit
yes, my lord,
66.
66.
But who is that Bila Bibi?
Mother. 66 voter list lordship will find at page 47.
But there, I think the name of your mother is different.
Bila Bibi,
Which page?
page 47, my lord.
No, somewhere I saw that your mother's name is different.
Now,
Bila
somewhere,
Bhanu or something.
somewhere, my lord, Bela.
Bila Bhanu Beva, yes, page
Yes.
51.
Yes, sir. Now 49 lordship will find the father's name again.
Just a moment. There's something I am missing.
And 51 lordship will find Bela Banu Beva.
No, but you
Yes.
see, there's no document to connect you with your projected parents. It's no
Now-
document at all.
Lordship kindly see 51,
Page 51.
page 51.
97 টা মালুর দেখুন নাই।
This is my lord uncertified voter list.
97.
What is this of 1997?
My lord,
No, that is not even an exhibited document.
Suleiman Ali.
It's not an exhibited document.
It was my lord in the WS it says my lord it was exhibited, but it was not discussed.
No. Come to page 65.
Mm. 65.
Six, 70, 97.
So next time when you appear before us, you cannot smile.
Subsequently, my lord, his name appeared in the final NRC, my lord, in the year 2019.
No, cannot is a wrong word. You should not. No, but the
Dr.
document is, we just can't interfere because of that document.
66, 70 lordship, and then 97 and 2008. In between, all other voters lists are missing. And there's no explanation to that.
Mr. Mandal, because of your smile, we give you one more opportunity to address us. We take it up next week. Be prepared. We are not satisfied.
My lord, till then some protection will be given. Otherwise, my lord, police is searching the.
No, that is why we are keeping it next week. You can merely say that you will not be deported.
My lord.
Both sides are represented. The records of the tribunal is received. List again on 6/11/2024. Next paragraph. In the meantime, if the petitioner is not deported, he will not be deported without further orders of the court.
Mariam Dudia. Naina.
List on date 6. Okay.
Next week.
6/11, my lord.
Hmm?
6/11.
6/11.
Item 10.
Lordship,
You have-
I,
You have influenced us with your smile.
My lord. Yes, smile is the, my lord, best therapy of me as well as for my client also.
Lordship, item 10, we have received the LCR. It is with us. Lordship will fix up this matter next week.
Give a date when.
6, did you? Lordship can fix it up on 6th, Lordship.
Hmm?
6th, Lordship can fix it up on 6th or 8th.
6th then.
6th, Lordship.
Okay. Both sides are represented. On the prayer made by
But they was to leaky to LCR anyway.
Ms. A. Verma, and at Standing Counsel for the Home Department. Matter stands adjourned today. List on
6/11.
6/11/2024.
Lord, I'm 24.
We'll take it up. Don't worry.
The time is 11 also.
Okay. 24.
Then to quality account. Then you to mark. Then to my follow LCR received আমার লগত আছে fix on 6/11. 10. Item 10. Yeah, we were asked to produce the LCR. So it's with us next week. Yeah. itu তো আমরা লিখি যে হ্যাঁ যাতে লিখি দেয় নিচে আমি প্রবেশ করে রাখবো then last file to Mahmood.
Upgraded item 24.
Lordship, item 11 also, we have the LCR. If Lordship could just record that also. Item 11 also, we have the LCR. Matter may be fixed on 6th, Lordship.
Even the detention
But
center,
the Lordship.
the petitioner is in detention, my lord. And it's an expiry order, my lord.
He said, I mean, next week fixed for so. As you know, Lord, not. Manjur, no?
Not be deported without further orders of the tribunal. Next paragraph, the Learned Standing Counsel for the Home Department shall transmit into a downloaded copy of this order to the detention center,
Yes, my lord.
Matia,
But yeah,
Not yet.
at Guapara.
6th, my lord.
6th.
6th. Alright.
Yes, Mr. Mahmood.
My lord. We can say the employer order page 66, right?
Item 6.
Last item 24 should be a record.
When discussion starts from page 67, bottom, the following documents have been produced by the OP along with her evidence on affidavit marked as exhibit A, B, C, D, E, and F. So onwards, Lordship may kindly say.
There is a missing link. One of your witness,
Yes, my lord.
they could disbelieve him.
That
Gambura or
Lordship
something. Where
kindly
is
see
that
first.
discussion?
My documents, Lordship may kindly see page 21. That's a
Yes, we got it. Page 68. Come to page 68. Your only link is that Gambura certificate.
No, my brother has adduced evidence. My brother's name is along with my father, and I have claimed that he is my father. So
No,
those
that's okay,
things
but then you discard your exhibit E. Exhibit E is the document proved by your Gambura. So if you say that you're relying only on your brother, not on this DW3, then you omit the evidence of DW3 and then proceed.
in addition to Gaura, there are so many other documents.
DW2 also, who is your brother,
Yes.
he did not prove anything
No, he
regarding his
proved,
identity.
he proved Lordship may kindly see page 31. This is the Jawabandi. Here, Sufia Khatun, daughter of Muhammad Ali. And page 33, Lordship would see Julhas Ali, son of Muhammad Ali. Okay, Julhas Ali is the DW2, page 33.
No, just some missing link.
33, Lordship. And his evidence is just page 48. Here, he has clearly said, the name of my father is late Muhammad Ali, and he has expired 3 years back. At,
Just a moment, there's something I'm missing. Just give us 2 minutes time.
Lordship will also see page 35, man.
This document is getting after passing of the opinion, Lordship. Mhm.
My lord, I am in detention
Lordship.
camp.
Lordship, she is in detention camp, Lordship. And Lordship. Lordship, since 2018, she is doing nothing, Lordship.
There's some inconsistency in the opinion.
Lordship.
Has to be interfered with.
Let the records come, Lordship.
In this case, we'll be releasing the petitioner. We'll give a notice, but
After arrest, Lordship, she approached report is honorable court, Lordship. Since 2018, Lordship. She is doing nothing, Lordship. After
No, no,
arrest,
no,
Lordship,
actually,
she approached
there
report
is
is honorable
reason.
court, Lordship.
There is reason.
it's a 2018 opinion.
Yes, Lordship.
Well, then 5 years you'll have to explain what has happened, Mr. Mahmood. Then I think we'll give you a notice before releasing you.
My lord may kindly consider I am 59 years of old and
That is okay, but 5 years explanation is not there.
explanation
You-
is there.
Apparently have a
But here, my
strong
lord,
point here, but still 5 years is
no.
too much. Then 2 weeks will not make a difference.
Here, my lord. Para 19, page 15, may kindly lordship say.
No, that's okay, but if you are coming after 5 years, 2 weeks more will not make a difference. Then we issue a notice. We intended to give you bail, but 2018 matter you are appearing now. No. But Mr. M.U. Mahmood, learned counsel for the petitioner. Respondents, Mr. G. Sharma, learned standing counsel for the Home Department. Mr. Puli, learned counsel appearing on behalf of Ms. Mr. A.I. Ali, standing counsel for the Election Commission of India. Mr. P. Sharma, learned government advocate appearing for respondent number 5. Next paragraph. In the meanwhile, the learned standing counsel for the Home Department shall obtain instructions as to whether they would be appearing for respondent number 4. Next paragraph. The opinion dated 6/6/2018 passed by the learned member, Foreigners Tribunal number 10th, Borpeta, in FT case number 35 of 2017. Is assailed in this writ petition filed under Article 226 of the Constitution of India. Next issue notice. Returnable on. You're giving 2 weeks time. On 22/11/2024. Yes, but the registry shall call for the records of the aforesaid proceedings before the concerned Foreigners Tribunal. And before that, you also say requisite extra copies of the print is served on the learned CGC, State and Learned Department Council within 3 working days. Next paragraph. Also issue notice in connection with the connected IA Civil 3241 of 2024. Then say call for the records. Next paragraph, the prayer for interim relief, as made in the interlocutory application shall be considered on the next returnable date.
Right.
Other motion matters will get deferred. Put it up next week. In divide, huh? Left over. Leftover motions will be split up in the next week. It will come. Mr. Sharma, did you get the instructions in the meanwhile for NRC?
Regarding NRC Lordship,
Huh.
Lordship.
No, get it, because you see there is a technical error which is happening in all the orders.
Yes, Lordship.
Because respond that NRC is unrepresented.
Yes, yes, yes.
So we are also anxious that the orders should not be interfered with,
Yes, Lordship.
merely because tomorrow you come and say that the NRC was not issued a notice.
Yes, yes, Lordship.
Because next week we'll devise a manner in which we take care of the NRC.
Yes, Lordship.
Otherwise there will be a-
Communication has been made, Lordship.
No, no, that is okay, but
Yes, Lordship.
please see, we are disposing of matters
Yes, yes, Lordship. I
in
understand.
the absence of the authority. So tomorrow, if the Home Ministry itself, or the state comes and says
Yes,
that no
yes.
notice was issued.
Yes.
And asks for a review of the order, then we'll have to exercise review.
Yes,
We don't want those multiplication of matters in the Foreigners Tribunal cases.
yes, Lordship.
We already have more than what we can decide. Correct. Now we counsel for the petitioner. List after a week.
Week lordship.
Item 6.
6 lordship, part 1 list. My lord, I have prior in item 15, my lord.
15.
1-5, my lord, 15. I have a medical emergency, my lord. Okay. Lordship will kindly fix the matter in the next week, my lord. Any day.
Okay. Same order. The advocate's name will be Z Hamad, HAMMAD.
Deeply obliged.
Lord, item number 14, madam. This is regarding a challenge to a corrigendum notice, madam, regarding an advertisement, madam. I need to take some instructions, madam. Let it come after 1 week, madam.
Okay. Same order. Advocate's name is Mr. R. Chakravarti.
Except I am appearing for the Tribunal University in this case.
You recorded, all sides are represented. You want your name to be recorded?
Because
Then say
I
Mr.
have
S.C.
to find my memo also.
Mr. S.C. Kyal, standing counsel for the Tejpur University, is also present.
Absolutely, lordship. Lordship, like to mention item 11 and 12, lordship, with consent of the other councils.
11 and 12.
11 and 12, lordship, conducting council, Mr. ARVI is hospitalized, lordship.
Oh, yes.
In 11, we are for respondent number 5, lordship.
11,
12, we are petitioner.
Oh, okay. 11, 12, you say both sides are represented. The on the ground that the learned counsel for the petitioner, holding the brief in WPC 6312 of 2021 is indisposed, the prayer for adjournment is allowed. List after
3 weeks.
List after 3 weeks. Okay. This
11 also.
the telephone number of Mr. A.R. Bhuya, please give it to the court master.
Sure, lordship.
Okay.
Lordship, 11 and 12 both.
11 and 12. Okay.
Of the lordship.
You see, all sides are represented. Yes.
May I please, Your Lordship, I'd like to mention item number 4. The conducting council is having some difficulties. Kindly pass over the matter for a day.
Okay. Same order, item number 4. Your name?
P. Naiding. P. Naiding on behalf of Mr.
P.
Naiding. I'd like to
Spelling. Give it to the court master.
Please, Lordship. Lordship, I beg to mention item number 17, 17,
17.
on behalf of NS Thakuria.
Okay.
Matter will
Same
be
order, your name?
A dash, Lordship.
Ms. A. Das of the parent state, Ms. A. Das. For the petitioner. Okay.
Always, Lordship. May I please, Your Lordship? Lordship, I beg to mention item number 8, Lordship. Kindly adjourn the matter for the day, Lordship.
8.
8, Lordship.
Okay, same order, all sides are represented. Your name?
A. Sharma.
Ms. A. Sharma.
If you please.
Your Lordship, I beg to mention item number 9 on behalf of ABT Hawk. Matter may be adjourned for the day.
Same order. Your name?
LP Bora. LP Bora.
LP Bora. Okay. Yes.
But actually, if I'm just mentioning item number 23, my lord, it's, some urgency is there, my lord. If your lordship will be kind enough, my lord, to take the matter today,
We'll try to.
lordship. But,
Upgraded item 19 to 22. Item 19 to 22.
These are contempt petitions where we have kind of filed reviews against the orders which are passed in the repetition, they're pending, my lord. That's it after 4 weeks, my lord, perhaps. Reviews have been.
What is the status of those review petitions?
My lord, notices have been issued. We are awaiting service. In some cases, the affidavits have been filed. It was a order, my lord, disposing of several lead petitions. Around 23 reviews have been filed.
Okay. I see. Mr. R. Borpujari, sorry, R. Mozumdar, learned standing counsel for the learned counsel for the respondent has submitted that the review petition filed by the state by the school education department. By the school education department in connection with the order so the order concerned is adjudication of the same is pending, and accordingly on the said ground, therefore adjournment is made. Next repair is considered and allowed. The matter stands adjourned. Today, next list after 4 weeks. A separate evidence, no? In all cases. Item 19 to
22, my lord.
okay.
Pleasure.
Item 23.
my lord, there is an honorable court's order, my lord. Lordship, kindly have a look at page 13, lordship.
Although Mr. Chetri, we are taking up your matter,
Right.
but in contempt, what can be very urgent?
My lord, since my lord, here this petitioner, my lord, it was supposed to be considered within a period of 1 month, my lord, as per the honorable court's order.
Then you're filing affidavit. You've given full weightage. You've given full weightage.
Yes, sir.
You file an affidavit then. They have considered and given full weightage of 3 marks out of 3.
No, here, my lord, as per the honorable court's order and the order that the 15 marks has to be added, that has been done by the selection committee, and it was forwarded to the authority concerned. This authority concerned has wrongly added the 3 marks, my lord, since it has been added already 15 marks, my lord.
and I have been found the first position as per the this selection committee, my Lordship, we have
Take
forward.
us to the observation made in the order. There is that.
Lordship, 7 and 9, Lordship. It appears from the communication dated 6/1/2020 that due consideration of the weightage for the 15 years of experience of the petitioner in spite of the order dated 21/10/2019 in ISO and so could not be given in as much as the order of the court was received by the authorities after the interview was over. The said reasoning of the communication dated 6/1/20 in our view would not be sustainable in as much as the court is in its order dated 21/10/19 in paragraph 4 and 5 had already taken note of their care submission of the petitioner that the
No, but what is the weightage for 15 years?
because
much is the weightage?
she was working since 2015, madam.
That is, we understand, but what is the weightage? What is the weightage point you will get for 15 years?
No, for 15 years, my lord, she was working since 2005 and
No,
after
you see, we are not interested in the dates.
Lord, for 15.
For 15 years of service, what is the weightage point? 1, 2, 3, 4, 5, 600 to 200, 500,
That-
600.
There is no points at all, my lord. But since the honorable court has directed, then accordingly, on the basis of that, the selection committee has decided, my lord. The selection committee already forwarded the papers, my lord, that I have, my lord. That this selection has already been completed, my lord. But only approval is awaited from the director and the secretary, my lord. And as per the rule, my lord, lordship knows, my lord, since selection committee is the authority, my lord, to consider all this aspect.
You see, we are not being able to follow you.
Lordship.
We have the standing counsel for the Mr. Pamane has produced a copy instructions saying that there are 3 marks for weightage, and full 3 marks have been given to you.
Now, the court said that these 3 marks, my lord, it was in general, my lord. It was in general, my lord, the 3 marks was given. But the court said that no.
Mr.
since-
Chetri,
No.
either I am not being able to convey it to you or I am not being able to follow you. What is the marks for the weightage? That is the first
Weightage
question we
marks
asked. You
are-
did not say that. Now the respondents say that 3 marks are the entitlement and you got full 3 marks.
No, lordship, kindly have a look, my lord, this.
No, we don't have that much of time today. A pointed question and a pointed answer.
Yes. My lord,
If I have
that
to
too.
find out, we'll take it up next week. List the
This-
matter, both sides are represented. The learned counsel for the petitioner shall address the court as to what is the weightage marks for 15 years of service. As per the.
There is no
agreement.
such, there is no such weightage, my lord, regarding all these things. Only court said, my lord, as per the direction of the court, that was given.
Then please tell us, you see, you say that there are no marks. Then the respondents have given you 3 marks and they say that that is the total entitlement.
No,
Now, where is the contempt?
no, my lord, there is, my lord, this honorable court's order, my lord, that has been.
No, then we take it up for hearing because we don't have time today.
Lordship. Let them file the affidavit, my lord, in the meantime, whatever.
That we were already issuing a direction. You
So-
said that no, there's. You should
Let
hear
them
the
file the
matter.
affidavit, my lord,
Both
they
sides
will-
are represented.
what they are taking, my lord.
Deal counsel agreed for the respondent. Place for is granted. How much time?
Lordship, 2 weeks.
2 weeks time to file affidavit in the matter as he has received instructions.
Lordship, that
Next, madam.
instruction may be
Copy of-
kept.
No, you take it back. The instructions in form of speaking order dated 19/8/2024, comma, as produced by the
Contentment number 2.
learned counsel for the respondent is returned.
Highly obliged.
24,
Lordship, here in this matter, I have just received telephonic instruction, Lordship. They will be furnishing me the wakalatnama by the course of the day, Lordship. So let it come in the next week, Lordship. I'll have my instructions as well, Lordship.
Okay. Mr. B.K. Sen, learned counsel for the petitioner is present. Next one, Mr. D. Upamanya, learned counsel. enters appearance for the respondent and place for him is granted. How much time?
Lordship, a week's time to file the
No,
wakalatnama
you
and
also have
obtain.
to file your affidavit.
Yes, Lordship,
much?
then two weeks, Lordship.
Place for is granted 2 weeks time to file affidavit in opposition in the matter along with his wakalatnama.
My lord, may fix a date, my lord, so that.
It's a content matter. You make a mention if it is not listed.
My lord,
List after 2 weeks.
otherwise it won't be listed, my lord, if your lordship.
You make a mention. We are permitting you. Make a mention.
Highly obliged.
The learned counsel for the petitioner is at liberty to make a mention if the matter is not listed.
I am obliged, my lord, deeply obliged.
Daily list item 1.
This is old pension scheme matter.
Yes,
Well,
ma'am.
new pencil, old pencils.
What has happened to the bunch of cases which were earlier being heard?
I don't have that inspection order. Even some appeal has also been
So,
filed.
I
Final
told
report-
you, this matters about old pension scheme was being heard.
My lord, one matter was there, my lord, Devashipura's court, Lordship's court, they have given a judgment, my lord. Purnima Hore.
That's why.
That was Purnima Hore's case, my lord. WPC number 6403 of 20.
I am not.
Teachers were allowed.
Old bench.
Except the study teachers, the drop teachers, OBB teachers, and the other teachers were not.
Coordinate bench.
You see, there's a previous order of this court on 3/5/2024. The question of referring to the policy decision has arisen because of the contention raised by the learned standing council BTC that the case of the writ petitioner does not stand on a similar footing as those teachers who are covered by WPC 59 of 2013, in respect of whom the state has taken a decision for regularization service of the petitioners therein. So this was an order passed
No,
to
that is,
your,
there was another case, analogous case. That was on, that's why, but it was separated. Another
Okay.
case was there.
so it is no longer connected.
No longer connected.
Okay. Your affidavits are filed in the matter?
My lord, it was
BTC?
filed in the month of June 2023, my lord.
No, BTC has filed an affidavit?
No,
No.
notice has not been issued, madam. Pursuant issued.
Notice not been issued.
Not.
This matter is being taken up for quite some time.
Yes,
Then times were taken, additional affidavit was filed.
Where is your cabinet memorandum? It is available?
Well, that is something different, madam. That is regarding the another
Oh,
case,
okay.
madam. That's why, madam, this,
Okay, so several orders are there which are clubbed for both the writ petitions.
both the petition, that later on it
okay.
has been separated.
Okay. Did you do it within 2 weeks, your affidavit?
Lots.
Mr. M. Sekia, learned counsel for the petitioner is present. Mr. S. Bora, learned standing counsel for the BTC,
I appear for respondent number 226.
representing respondent numbers
226.
226.
6.
And I am representing.
And Mr. A. Fukan, learned standing counsel for the Elementary Education Department, representing respondent number 1. Raised for and are granted 2 weeks time to file affidavit in opposition in the matter. Next para, list after 2 weeks on a date to be fixed by the registry. Next para, liberty is granted to the learned counsel for the petitioner to make a prayer for listing if the matter is not listed.
Oh, hi.
Yes, this is the judgment.
Yes,
Ah, judgment. Okay. Very good judgment.
oblige, your lordship.
Item 2,
What is the date of the order?
Order, my lordship, page 10.
Give the date of the order. Give the date of the order.
Order, my lordship. 11/04/2020.
11,
11/04/2023.
23.
23. A similar earlier jointly filed a writ petition and already
just a
one
moment.
case is pending, my lordship.
Just a moment. Where is the order? Page?
Yes, my lordship, direction, my lordship, 15. Para number 10.
No, that's also. What is the Ziggy that we say? 1, 3, 4, 6, 8, 9, 11, 12, 14, 15, 17, 19, 20. Heard, Mr.
And Islam, my lordship.
And Islam, the constitution, alleging willful disobedience of the order dated 11/4/2023, passed by this court in WBC 8840 of 2018. The present contempt petition has been filed under section 12 of the Contempt of Courts Act, 1971, read with Article 215 of the Constitution of India. Next, for the issue notice, returnable in 4 weeks. Next, the petitioner shall take steps within 2 working days for service of notice on the respondent by registered post with AD. Next, the pendency of this contempt petition shall not be a bar for the respondent to comply with the order under reference. Next, list after 4 weeks.
My lordship, my name is not reflected in the cause list.
Okay. The registry shall reflect the name of Mr. N. Islam, asking for the petitioner while listing the matter next.
Oblige, my lordship.
item 3,
Another contempt petition, my lord. Page,
What is the date of the order?
date of the order is 16/8/24.
15?
Relevant portion is at page 53.
16/8/24.
Yes.
Okay. Same order.
And only, my
Beautiful.
lord, registered AD, with AD and also my dusty.
By the state. Okay. Order under contempt is page 1.
Because of non-compliance, my lord, the petitioner unable to continue that diploma course and graduate level course in pharmacy.
Okay. Mr. Bididas, Senior Counsel, assisted by Mr. M.J. Kadir, Counsel for the petitioner. And last, same order, last line is the same. pendency of the this contempt petition shall not be a bar. Same order.
Registered AD and Dusty, man.
Okay, notice by way of Dusty, registered post with AD, as well as by Dusty, by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Okay.
3 weeks.
4 weeks. You want 3 weeks?
Yes, it is because we are unable to.
Okay. Notice by determine 3 weeks, make it list after 3 weeks.
Item 5. Item 5.
BTC matter, you have instructions? No.
That's to be diverted, madam. Still goes up to 2 weeks.
You have been given extra copies. Are you aware? No.
Extra with one.
Given. Okay. There's no representation from the petitioner. For range of justice, the matter stands adjourned today, list after 2 weeks. For obvious reasons, you know, we are not recording your presence.
Item 7.
Where is your appointment order? Sorry, what you call leave application without pay. When did you join?
Joining report is there, Lordship. If you find in the page number 14. 1/4.
1/4.
Lordship.
Does it comply with all the requirements?
17/7/2023. Lordship, I have my prayer is very limited. Lordship,
No, limited or not, you please respond to the court query. Because in page 13, your leave was never granted. So question of joining never comes. So therefore, we are asking you a question, give a pointed reply.
Lordship, may peruse the page number 12. It reflects that my leave was granted. I am 1, 2, 3, 4. Paragraph number 5.
Page 12.
Page 12. From the bottom, paragraph number 2.
We issue a notice then.
Lordship,
Lordship, issue notice as well as my lord, also reflect the name of technical assessor because names have not been reflected in the call.
Lordship, may I submit, Lordship, please, page number 16. Just let them take a call, whether I'm entitled or not. The district mission coordinator requested the state mission coordinator to send him, to give him instruction whether my salary shall be prepared or not. The prayer is only limited. On that, the answer of the state mission coordinator may be positive or negative, it is up to them. They are not doing nothing, that is why this petition.
No, we don't know under the service rules unless your leave is granted and your so that leave is regularized. I don't know whether you will be entitled to your salary, current salary.
That let the mission director take a call. I'm just My peer is very late.
notice when I am responding.
But Mr. F.Z. Mazumdar, learned counsel for the petitioner. Agitating non-receipt of salary since 17/7/2023. The present writ petition has been filed under Article 226 of the Constitution of India. Next para. Issue notice returnable in 4 weeks. Next para. Mr. Will be appearing for education. You are there.
For Lordship,
Miss
S4.
S. Kaur, learned standing counsel for the Education Department, representing respondent number 1, and Mr. S. Bora, learned standing counsel for the
Two and three.
Service Shiksha Mission, representing respondent number 2 and 3. Then if you are representing respondent number 1, you will also appear for 4. 1 and 4.
For 4.
1 and 4. For 2 and 3. Accepts notice on behalf of the concerned respondents. Therefore, no steps is required to be taken by the petitioner, however, requisite extra copies of the writ petition be served on them within 2 working days. Next para. The pendency of this writ petition shall not be a bar. For the, where is your representation?
Representation, I have not submitted, but it is the district mission coordinator who has requested the state mission coordinator whether my salary shall be prepared or not. Page number 16, Lords.
We shall examine the claim of the concerned, the competent authorities of the respondent shall examine the claim of the petitioner for releasing the salary of the petitioner from the date of his joining. Next, list after 4 weeks.
Well, Lordship will direct the registry to reflect the name of the standing council SSA. Because today it is not
Standing
reflected.
counsel,
SSA.
SSA, okay. The next paragraph, the registry shall reflect the name of SC, SSA for the respondent numbers 2 and 3 while listing the matter next.
Can I prep for a date, fixed date?
You're not giving a date. Make a mention.
Lordship.
Because
Supply.
by the time we are giving you date, prayers will be start coming for adjournment after December vacation. Yes, item
Supply item 26.
26. Yes, Mr. Roy Chaudhary.
Wait, Mala, this is in relation to the admission into the MBBS course. Today on 30th October, Mala, a notification has come out where it has been, for provisional counseling, it has been extended up to 5/11/24. Just now I have them in mobile at that. Mala, now I take your lordship to page 24. 23, Mala, of my writ petition.
23.
23.
Yes.
National eligibility come entrance. Your lordship will find all category general EWS.
Mr. Goi,
Well,
without making any observation, can the provisional, what do you call, what is it,
I've got the
counseling?
instruction. Let him place the facts. I've got the instruction.
You got the
Yes,
instructions?
yes.
Okay. Yes,
My lord, he is general EWS. Your lordship has got it?
yes, yes.
My lord, then the first counseling, second counseling was over. Then at page 26, it was cancelled.
Yes.
Then, my lord, cancel at page 27. Their 5% quota, it was hereby cancelled. Then in the, my lord, the third counseling at page 29,
Yes.
serial number 1228.
Yes.
My lord, my name is there. It has been shown as general, no EWS, and no college has been formulated against my name. Then, my lord, I have filed an additional affidavit today. Your lordship will find where, my lord, at page 49. Page 49. Page 49 in additional affidavit.
Yes.
Serial number 1536. I have been shown in this Director of Medical Education Assam, NEET UG 2024, General EWS.
Yes.
My lord, now at page, it is 50. I think it's 50, my lord, where Annexure C, the last 1283,
Just a moment.
where the marks of it.
Just a moment. Yes.
My lord, where the mark obtained here is the last person in this list is 558, and a college has been provided to her. And whereas my marks was in page 29, 563. Here, this
Yeah, page 50, which entry?
page we last, my lord, 1283.
1283, yes.
The mark score is 558.
558, yes.
And at page 29 of my writ petition, you also will find my marks was 563. Then at page 51,
Yeah, just a moment. Page now.
now
50.
page 51, 50 may not the last person who got the mark as 558, college has been provided to that candidate. Husnara Begum, page 50. Nalbari College, Medical College. At page 51, 1294, score marks 557, Yasin Ali, EWS, college has been provided.
Serial number?
1294. Then at serial number 1302, Shubroto Sen, 557, EWS, college has been provided. And page 54,
Just a minute. Is then
My lord, at page 54, your lordship will find
yes.
my roll number neat. This is neat roll number. Preference at 14, my lord, 201 is given. 201 reflects for dental. Code number of dental.
Okay.
And at page 56, my lord, Stray vacancy round, page 56, MBBS course, unreserved 10, BDS course 23.
Yes.
But in the EWS column, MBBS course has been shown as 0 and BDS course, it has been shown as 5. My case was that, my lord, from the very beginning, I have shown myself as EWS, general stroke EWS. But they have shown me as a general candidate. Last occasion when it came up, my learned friend said that the cutoff mark was 564. That was why I was not considered. My marks is 563. But I am a EWS candidate, whereas others has got 557, 554 and others.
No,
They
but
have
this
been-
page 56 shows that MBBS course, the breakup is there, EWS is 0.
My lord, EW is 0 because the person
That's
below
okay,
me.
whatever is there, but BDS course,
My lord,
Five.
may I, my lord,
Five.
interfere? To cut short, my lord, this particular confusion in the form, lordship may kindly turn
no,
to
let me
page.
complete, let Mr. Roychoudhury complete, then he may have something to say.
No, my lord, why, my lord, I'm telling is, he has applied as, my lord, general candidate in his own application form. That's why, my lord, right from the beginning, it has been shown as general. I have downloaded the form and it's there, my lord. That's why I'm saying, my lord. Had he applied as EWS, my lord, he would have been, my lord, now as a, my lord, MBBS candidate.
Is it?
Yes, my lord. This is the application form, my lord, a candidate has to fill up during the first round of counseling, and it remains in the system. Lordship, I have tick marked it, my lord. I will give a copy to Sam also. Lordship will see the category of the candidate
But you
general.
need to give a copy to
Yes,
Mr.
madam.
Roychoudhury, let him
Next,
take
my lord,
instructions.
EWS, no. EWS, no.
You take it up on Monday then. Mr. Gogoi,
My lord.
give a copy, we take it up on Monday,
Lordship.
because it's medical education, we won't
No,
just.
I understand. Madam. In fact, my lord, that's why in page 24 also it has been shown as a first round, my lord, general candidate. He never protested. He ought to have approached the authority at that time.
We take it up on Monday. You take instructions, because if you have applied as
Yes, it is
a
there in the system. I
non-EWS.
can give a copy again.
Huh.
He has committed
Because
a.
my instruction was that, let it come on Monday, madam. My instruction was this, that some candidates which have been shown as a general, and ultimately in the third round, they were allowed to produce their EWS certificates.
That's a different
We'll
issue.
put a
My lord.
notice.
His own case, my lord, is that he applied as general.
But if I am in the national eligibility come entrance examination, I have given as a general and EWS. That certificate was there,
No,
and even in
Mr.
the
Mr. Roychoudhury, this leads to a different road altogether. Because if you are alleging, then there must be allegations and those people must be made party here.
Yes.
My lord,
Then we can clarify.
another one thing is there.
Yes.
There is a judgment from this court. When some institution is appointing somebody or getting admission for somebody, then making that institution itself is enough, not require of selected candidates to make a party.
No, not selected. At least there is any allegation.
There is a
That,
judgment.
I can place that judgment before your lordship.
It's okay.
A division
Once you
bench
say
judgment
there's
of
a
this court.
judgment, we don't disbelieve you. Heard Mr. B.K. Roychoudhury, learned counsel for the petitioner, as well as Mr. B. Gogoi, learned standing counsel for the health medical education department. Next para, in course of his submissions, the learned counsel for the petitioner has submitted that the petitioner was a economically weaker section within bracket EWS for short bracket close candidate And although some EWS candidates who were who had got lower marks than the petitioner were admitted in the
My lord, one thing, just a moment, my lord, my friend has instructed me. This online is of Asif Iqbal Hussain, whereas my name is Asif Iqbal Islam. This online belongs to, this is of Hussain. And I have been, my name is Islam. It's different person, this online. It belongs to somebody else.
Well, let it be on Monday, my lord, because
My
this
lord,
is the main issue.
then, my lord, because this document is not a wrong document, on prima facie case, my lord, 5th is the last date.
5th is
The last date.
Tuesday.
Tuesday.
And my lord, my written instruction says, my lord, there is no, as on date, there is no vacancy for EWS.
It's okay, but let him have the counseling.
Yes.
We,
The counseling is over. My lord. There is no seat as on date.
no, that's okay, but he has not yet been admitted.
No,
He has
no.
not been counseled. Now the dispute
So, my
arises.
lord, I will place the actual my lord form, my lord, because here also, my lord, they have stated, my lord, he is not a, he is considered as a general candidate, not as EWS.
No, we understand, but there is a difference in name again.
No, that I will place, my lord, on Monday, my lord. Now it will again, my lord, difficult for
If
me.
some protection is not there, tomorrow they will come and say, my lord. If
No,
now
today only I am saying, but
suddenly,
there is no
if
seat.
by placing a document, I can find out there is absolute wrong in the name, that itself shows, my lord, I have a prima facie case.
We'll protect you.
No, my lord, there is no seat, my lord.
It's okay. We'll still
That is
protect
a
him.
different stand now, my lord.
No, I am placing the written instruction today. It's there, my lord. You can place it.
No, we have it,
Yes.
but then there's a difference of name.
No, right now, my lord, just now, after getting this particular instruction, I just asked them that give me the form. Probably, my lord, in downloading, there may be something.
No. Hussein and Islam are two different.
That I
dates.
can, Lordship may take after some time, my lord, I will have the form as the
Yes.
last item, my lord. In that
Yes.
case. I can clarify, my lord.
Yes.
Because
After some time.
sometimes it happens, my lord.
It's okay. We take it
Otherwise,
after
if
some
it
time.
is bona fidely is, my lord, entitled, that's a different issue.
It's okay.
No, I will place it, my lord, after some time.
Item 10. Item 10.
Is the lordship.
Yes, Mr. Gupta.
Last lot occasion, the finance was asked to file an affidavit, my lord, just clarifying certain things. Otherwise, it's a matter, my lord, regarding, my lord, payment of, my lord, upgraded scale. In the meantime, the person is retired. And, my lord, our case is that, my lord, it's the school was amalgamated. My lord, pursuant to the amalgamation, my lord, since he is, my lord, graduate, my lord, he's having graduation, my lord. Following the retirement of the incumbent graduate teacher, my lord, my case was that I'm entitled to, my lord, the graduate scale of pay. My lord, similarly situated person was also granted, my lord. I have a next one order. Now, my lord, that order lordship will find it page 30 of the writ petition, my lord, with regard to the similarly situated person.
But this FR 22
Correct.
A2 that gives you only a minimum pay scale. When appointment to the new post does not involve such assumption,
Correct.
he will draw initial pay, the stage of time scale when is equal to his substantive pay in respect of the old post, or if there is no such stage, the next below that pay plus personal pay equal to the difference. And in case, and in either case, will continue to draw that pay until such time as he would have received an increment in the time scale of the old post, or for the period after which an increment is earned in the time scale of the new post, whichever is less. But if the minimum pay of the time scale of the new post is higher than his substantive pay in respect of the old post, he will draw that minimum as initial pay.
Right.
Then
My lord, the finance department issued a notification, my lord. That is where, my lord, why, my lord, the finance was asked to clarify. By that notification, my lord, they were given this, my lord, scale. And, my lord, initially, my lord, it was, my lord, the procedure that was, my lord, adopted was, my lord, that they used to, my lord, upgrade the teacher, my lord, as per 2011 OM, my lord. That, my lord, they say was subsequently, my lord, was my lord, discarded. And then, my lord, 7 February 1995, my lord, there is a, my lord, finance department OM, my notification, my lord. Sorry, rather, my lord, it's a education department notification based on, my lord, based on, my lord, the finance department's, my lord.
notification, can it
My
be
lord,
permitted to amend
that
the
was, my lord,
fundamental rules?
that was the arrangement, maybe, lordship, you see the order of, my lord, amalgamation, my lord.
Where is that?
That is at page 19, my lord.
Yes.
Clause 6, my lord, without prejudice to upgradation of scale of pay of this, when this amalgamation took place, my lord, in the schools, my lord. It was also with the condition that without prejudice to upgradation of scale of teachers working in ME Madrasa in the intermediate scale of pay. Now, in the intermediate scale of pay, my lord, ME Madrasa had said, my lord, this intermediate scale of pay, my lord. Now, when this was, my lord, amalgamated with the high school, my lord, then, my lord, there was a notification with which, my lord, with regard by which, my lord, after retirement of the incumbent, my lord, graduate teacher, my lord, these people are upgraded, my lord, and, my lord, that was
So just
how
a
it
moment,
continued.
the 6 says without prejudice that will take an arrangement for function of the terms and conditions without prejudice to upgradation scale of pay of teachers working in ME Madrasa at immediately
intermediate scale of pay.
intermediate scale of pay.
So there is a, my lord, there was, my lord, the practice of upgradation, my lord, that's being followed, my lord. In fact, there was a my lord, OM
It
which
says
of
without
course,
prejudice.
yes, my lord, my lord, there was a, in fact, my lord, there was an OM of 2011, which of course is not here, my lord. The next, my lord, but then this has been referred, my lord, in page 25, my lord, next 7. This is 23, not 11.
You see, Ms. Kaur, then we'll have to allow this repetition.
Lordship, Lordship, we have filed our affidavit, Your Lordship.
That's why after only looking at your affidavit, we are saying that we have to allow the repetition.
Lordship.
You don't file a paraphrase reply. He is referring to the OM at this annexure 4 at in the repetition. At paragraph 7, you don't give a reply. You don't even clarify that the petitioner is not entitled to the higher pay. You said nothing that amounts to admission. And my school was a very difficult school.
Lordship. Lordship, what?
You understand what I mean to say?
Lordship.
Yes.
Lordship. Lordship, because earlier petitioner was working in ME
No, you
Madras,
see,
Your Lordship.
Mr.
Lordship.
Tata is pointing out towards the annexure.
Lordship.
He says that without prejudice would mean
Upgradation
that he'll
scale.
get the upgraded pay.
Lordship.
Now to that you don't respond. That means it's an admission.
Lordship.
Rather, what they're saying is that since I was I was in a elementary school, I was upgraded. Therefore, it is not applicable. It cannot be, my lord. Once I become a part of the secondary department, my lord, the secondary department circular becomes applicable to me. The stand of the education department, my lord.
Because if it amalgamates, you'll have to, if you don't specify, the benefit of the amalgamation is received by him. Then you can't stop it.
And my lord, in the earlier case, my lord, they had agreed, my lord, to give the benefit, my lord. Page 30, my lord.
Page 30.
Page
30, my lord. Similarly situated person, my lord.
30.
30, my lord.
Because
Para 3, my lord. The judgment. And pursuant to this, the benefit has been granted, my lord. This has not been, my lord. To the similarly situated person, the person has got the benefit, my lord.
the pay scale of senior classical teacher. Senior classical teacher.
You are in your service rules have which rules?
Well, initially I was in the elementary, my lord. So
Now,
my lord, the secondary rules will prevail, my lord.
secondary education rules.
Education rules, my lord. Because now I
When
am
will I
in the
get it?
secondary department, my lord.
So when will I get
With
it?
amalgamation.
Which page will I get it? What is the qualification prescribed for the post you are holding?
My lord, the post, my lord, actually, my lord, since my lord, I was the holding my intermediate post, my lord, with the intermediate scale. Now that is, of course, my lord, in the secondary department, my lord, that intermediate scale is not there. It's a graduate scale, my lord.
No, but what is the education qualification? Do you hold the requisite?
I mean, I have degree. I am a degree holder, my lord. I hold a degree, my lord. I also, my lord. I am in fact a master degree holder, my lord. That I have, my lord, mentioned, my lord.
You're master degree holder.
Master degree holder, my lord. I'm an MA in Arabic, my lord, having my completed my master's in 1988, my lord.
It's okay, but where is the prescription of the
My lord,
qualification?
as far as the qualifications concerned, my lord.
Sorry, please tell us, why should we spend our time when you don't file your affidavit? Why should we try to find out read the books and find out the answers?
Lordship. But this was the instruction that was provided, your lord. Lordship, if lordship allows, then I can let.
No, no, I'm not allowing anything.
Lordship.
Unless you make a prayer, why should I allow it? I
Because here, your lordship, as your lordship has pointed, your clarification is required, your lordship, as to why.
No, I am
point-
only pointing out to allow the writ petition on admission.
Lordship, before allowing lordship, will grant me some time, your lordship, so that I can clarify, your lordship. I can,
But will your authorities respond? Are they interested? Take instructions whether they have pen, pencil, meeting hall, files. You go out, come after 5 minutes, ask them whether they have everything with them. But then they will say it's an old matter, we lost the file. Man has retired, we sent the file from one section to another section.
because the petitioner lordship,
No,
his
you see, we are anxious because the petitioner is retired.
lordship, he has
Now, please
retired.
take instructions whether they have the file or what is the status. Within how much time they will give you instructions. Vague things will not work once he is retired. You please step out, have a phone call and then come back.
Lordship.
And take it after some time. If you want to file an affidavit or get instructions, please first take instructions whether they are capable of giving you instructions.
Lordship.
2015 matter, he superintended one. Mr. Dutta,
Superintendent, my lord, he was at that point of time, my lord. He's 6, my lord, so my lord, 19, my lord, he might retire.
19.
19, my lord.
So now we are 23.
23.
Please get instructions this one, after some time.
Well,
Item 13.
May I please, your lordship? Matter pertains to my lord. Page 35.
Lordship,
Yes.
here lordship, as per our department's order, there is an affidavit ready, but in our record, I have not seen that affidavit. It's supposed to be filed in June itself. So
No, you see, retirement benefits, you are taking an adjournment, you are looking at a cost of 50,000.
lordship here, the
Last month, my lord, several occasions they have taken time.
50,000.
Ultimately,
in our affidavit, we have clarified why the petitioner is not entitled.
No,
Petitioner is
then we proceed with the hearing. You see,
petitioner is the wife of the deceased employee,
yes.
and during the tenure of his service period, lordship, he never challenged the termination order, which was passed in terms of the this honorable court's order in a different writ petition, lordship. So that we have clarified in our affidavit.
my lord, this is totally wrong submission, my
No,
lord.
just a moment. Once he's.
My lord, similarly situated person already. My lord, this
No,
honorable
it's
court
not a
disposed
question
of.
of similarly situated. You are.
He is not the petitioner.
Similar
you
is
are-
already disposed of.
Petitioner here is not the government employee, lordship. The petitioner's husband was the teacher, lordship.
Was the husband of your petitioner service terminated?
No, my lord. Never terminated. Does
But
not
our
receive, my
affidavit,
lord.
it reflects, lordship, although the affidavit
No,
is
just
not
a
on
moment. You begin with your matter. Yes.
My lord.
Yes, you start your submissions.
Well, petitioner's husband appointed in the year 1989, my lord. And my lord,
First question is that are you a part of 355 terminated teachers?
no, my lord.
No. Okay.
And my lord, August 2007, the authority has stopped my husband's salary, my lord. He came, my lord, before this honorable court. And the honorable court, my lord, disposed the petition with a direction to examine the petitioner's claim, my lord.
Where is that order?
My lord. Annexure J, page 37, my lord.
37.
petitioner's husband name, my lord, petitioner number 1. Subsequently, my lord, all the petitioners are regularized and released their service, my lord. In these petitions, okay, that's a petition. And my lord, one similar situation person, my lord, already approached before the Honorable Apex Court, my lord. The Apex Court only directed to release the all service benefit, my lord, annexer L, my lord. Page 45.
Just a moment. What is the period from when your husband's retirement benefits are not given or salary is not?
Since petitioner's husband, my lord, died on 28/8/2013, my lord.
28/8/2013.
2013. my lord.
You have filed your affidavit in the matter?
Lordship, the department's records shows some affidavit is ready, but it has not been filed, Lordship. So Lordship may
No,
kindly
then-
allow,
No.
here Lordship, what happened? In
That
the
cannot be
affidavit,
allowed.
which seems to have been appeared, and Lordship here, Lordship may kindly peruse page number 44, the order which has been challenged now by the petitioner. That speaking order, whereby
No,
the
we cannot allow that unless you pay cost. And cost will be quantified at 50,000.
Lordship here, what happened? Lordship, kindly peruse page number 44 once.
No,
Lordship.
no, you see,
Lordship,
instead of perusing the pages,
Lordship.
I am perusing the order dated 5/9/2024.
So
This
many orders,
says,
my lord.
this
Lordship,
says prayer is allowed as a last chance.
Lordship, Lordship.
Now, if I
And
have
even
to,
today, the record that has been sent by the department also, there is a affidavit ready where that detail elaborately that explanation has been given. Why the petitioner is not entitled for the pension because
you
the
see, if you don't file it,
Lordship.
why
The,
should the
the
petitioner
petitioner was terminated.
suffer?
Now the main the order which has been challenged now by the petitioner is of 5/5/2000. Lordship, kindly page number 44. This order was passed in 5th May 2015. Whereby it has been in the findings it has been said. 44. A show cause
No, no.
notice were issued to the petitioners
Mr.
and the
Sharma, it doesn't
replies
take us anywhere. That doesn't take us anywhere.
Lordship.
It is an order of 2015,
Lordship.
challenged in a writ petition filed in 2017.
Lordship.
Will you say that it is not maintainable?
No, Lordship.
Then,
Otherwise
My
also,
lord, 18/6/2016, they himself noticed to the petitioner's husband, my lord. Page 49. Where was? On that, in that time, my lord, the petitioner has already died. Even my petitioner's husband, my lord, already confirmed their service. Page 25, my lord, annexary.
Page?
25. Service is already confirmed, my lord.
You please show us your copy of the affidavit you are having, Mr. Sharma.
Lordship.
Let us see.
It is in the department's office record only.
That's okay. You see, it is good. You are saving so much of government money. Mr. Borpuzar will be so happy. Printing cost 2 or 3
Well,
rupees
I'm
of
sorry.
printing, 10 pages of printing, extra copies 5 you will have to give.
I'm
So
sorry,
50 rupees you are saving instantly for the government.
I'm sorry, Lordship, how it has been left out, Lordship. Even my learned friend also has not received the copy. So it seems that the affidavit has not yet been filed.
No, that is good. Always remember surf excel. दाग अच्छे हैं. Once you save for the government, your officers will be getting these financial prudence awards. No, and start it. No, we allow the writ petition. You have not filed an affidavit. This can't be allowed. 2017, we are now in 2024. You can also step out and take instructions. If you want to file affidavit, 50,000 cost. If you pay, you succeed, you get an adjournment. You can step out, ask your director. If they are ready to pay cost to the petitioner to be credited to their bank account, to her bank account within 7 working days. It will allow your prayer for adjournment.
Possible fix next week, Lordship.
No, 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 no. Today, we gave you 10 minutes time. Tomorrow is another day. You take instructions. If you want to pay costs, we allow you. Otherwise, we allow the writ petition. After 5 minutes, we are taking it up. Take instructions.
16.
Well, in this case, the petitioner is active by my advertisement, madam. Annexure 5, page 16, type copy is at page 15, This part is advertisement, a post of library bearer is vacant and it is required as per advertisement, the roster point number is 6 and it is to be filled up by OBC and OBC. The petitioner, is working in the said.
You don't only have to satisfy us on 3 points.
Yes, madam.
Number one, that whether the petitioner is SC or OBC,
Petitioner is SC,
he is an SC category.
He's an SC.
Now, whether this post is earmarked for which category?
Well, as per this advertisement, OBC, but according to us, it should have been either SC or unreserved.
OBC. Now, what is the, as per the service rules, what is the maximum age of recruitment?
Well, he has crossed it,
He has crossed it.
During the pendency of this case, he has crossed it.
But then in view of these 3 points, how do we help you? That is the 4th question.
He has crossed it, in fact, now. He has crossed it.
Huh?
He has crossed it.
No, that is why this 4th question.
Yes, that is.
How do we help you? Because the court would have no power to convert a vacancy from a SC category to OBC category. That power we would not have.
No, here, the ground on which we are challenging is that the post, that is advertised, it was once held by one Vipul Chandra Das, who was actually appointed in an unreserved post. Although he belonged to SC, but it was an unreserved post. And as the roster point is shown to be 6, so according to us, the first replacement, it is the first replacement. First replacement, it should be by SC, But according to them, there are 5 posts. Vipul Chandra Das, he retired. He was an unreserved category. So if roster point number 6 is taken into consideration.
But how do you respond to this page 42? Is the advertisement in contrary to this page 42?
So, it doesn't say anything against us, Only thing is that, it is the initial recruitment followed by replacement. Actually. What is
That we don't know. You see, somebody may be holding a office rightly or wrongly, that we don't know at this stage. But now when the advertisement is coming and the posts are now classified under the roster points, very specific earmarked posts. The only issue is that whether the advertisement is in contravention to the roster point.
Yes,
it is
not in contravention to the roster point as per Assam.
Not in contravention.
Not
Page
40, as Lordship has rightly pointed out, 42 as well as page 41.
Page 41.
the folded page, my lord. This is grade
So if
4.
not,
So,
then we can't interfere if it is not there.
my lord, grade 4 is a cadre strength of 5, my lord. So if my lord comes to page 41, it has to follow the else pattern. Cadre strength 5, as against that, cadre strength 5, initial recruitment, it was for STP. First replacement is OBC. So it is as per the roster. And furthermore, has rightly fallen from Lordship's mouth, my lord. I have also put it in my affidavit, my lord. He is aged more than 45 years. So even if he is an SC and the relaxation for SC is given, then also he crosses that upper age limit, my lord. He is not eligible. On both counts, my lord, the petition.
Then Mr. Chaudhary,
Yeah, actually, my lord, what they are trying to, as per the advertisement, my lord, my lord, the post is roster point number 6, my lord. I want that the post is roster point number 6. So if roster point number 6, if according to my learned friend is considered in L pattern, then the first replacement is by unreserved category. Roster point, we are on roster point number 6, my lord. This is not initial recruitment. That is a difference. Initial recruitment and it is replacement. Our case is it's a replacement. Since it's a replacement, it should be
where is the advertisement?
advertisement, my lord, at page number annex of 5, my lord, page number 15.
1-5.
And my lord, the paper cutting is at page 16.
You fail here also.
Roster point.
It's a direct recruitment.
No. This is because one
If it
person.
is a direct recruitment, then the first column will come into place.
No.
Second column, initial recruitment.
This is direct recruitment, but it is replacement, madam. Although it is direct recruitment, but it is replacement. Initially, the
Replacement means?
Replacement means that first, suppose initially a college was established. Initially, as per the roster point number 1 is given to unreserved, number 2 is given to SC. Then, suppose that number 1 person retires, number 2 also retires, then it will be given as per it will be a replacement. It will not come in the earlier manner. It will be a different manner, as because it is a replacement. As given in the this appendix to the
no, but it's a direct recruitment.
Tribe, my lord.
It's a direct recruitment.
No, direct recruitment, I understand, I don't know, but it is replacement, my lord. That is the difference. It is replacement. Initially, this college is not newly set up. It was set up earlier, and this post was actually held by one Bipul Chandra Das earlier. So, as it is replacement, so it cannot be OBC, to my understanding. This is the replacement pattern, my lord, as given in the book, my lord. Assam,
okay.
Scheduled caste and scheduled tribe reservation of vacancies, service and post rules.
You say that recruitment, if it is under 6, that will be 7 would be unreserved. It goes to roster point of 7. It goes to roster point number 7.
What my friend is on is, my lord, since the cadre strength is 5, so the next recruitment will be 6. Be that as it may, my lord, even if it is initial or 1. But if my lord comes to page 41, that will clarify, my lord, the pattern.
We understand. You see, under the roster point, 100 points has to be exhausted,
Yes,
right?
Yes, ma'am. Yes, ma'am.
Then it goes back to the
yes, even if
initial
it is,
position.
Even if it is initial recruitment, then also, my lord, roster point number 6 is OBC. And if what my learned friend has submitted, my lord, replacement, then also, if my lord comes to page 41, first replacement is OBC 6, which is OBC. So in any case, it is OBC. Because the replacement is as per the initial recruitment.
No, because then, if is otherwise right, 6, you see the roster point,
my lord.
6 is OBC.
OBC, yes, my lord.
Then if it is replacement, next is UR7.
No, my lord, this is now for roster point number 6, not replacement of roster point number 6. 5 are already, I have annexed the roster register also, my lord.
you want to say that once the post is earmarked for OBC
My lord.
and is falls in roster point 6, so
My-
any replacement will be of the same category.
It,
OBC 6.
My lord, if it is 6, my lord, then it has to be 6. Now we are on roster point number 6. If the next vacancy would be roster point number 7, but we are not on 7, my lord. 5 it was already there, so now it is 6. 6 is for OBC, my lord. If my lord comes to the roster register, my lord, from page 45.
No, please, I'm still not very clear. You see, the cadre strength is 5.
5.
Let us say that the cadre strength was established
My lord.
in the year 2022
My-
or 2020.
My.
So 2025 are there.
Right.
So therefore, we have to cover up all 100.
My lord.
So for 100, if the cadre strength was 5,
My.
next recruitment for replacement
My lord.
would have to be 6.
Would have to be 6, my.
Correct?
Yes, my.
And then so on and so forth till we achieve the
Yes,
100
100
point roster. Correct.
Right.
Now, this initial recruitment in this page 41
Right.
is OBC 6.
Yes, my lord.
Then when you come to the first replacement,
My lord, here initial recruitment is not 6, my lord. This is number 6.
okay,
If we go by initial recruitment, then also it is OBC. And since it's a cadre strength of 5, as per the government's direction, if we have to follow page 41, for cadre strength 5, the first replacement would be OBC, my lord. If my lord follows the third column against cadre strength 5.
against
Re-
cadre strength 5, yes,
5, my
OBC
lord.
6.
Replacement number 1 is OBC,
OBC
6.
6.
So even if we go by initial, because this is just interpolation of the numbers 6, 7, 8, 9 in the horizontal column, my lord. The vertical is put in horizontal. If lordship observes, the horizontal column against cadre strength 5 is 6 is OBC. In the initial, that is second column, my lord, 6 point is OBC, 7th is unreserved. In the horizontal against cadre strength 5, 7th unreserved, 8 SC in the initial x-axis of initial recruitment. In the horizontal y-axis, my lord, 3rd is SC, and so on and so forth, my lord. This is just an interpolation of the vertical column into the horizontal row.
So it moves one step up
Yes, my lord.
in the next column.
Yes. So my humble submission, my lord, in both counts, the petitioner has no things. First, no locus. On ground of
Everybody says that civil procedure is tough. Yes, and what we're trying to explain to us.
My explanation is that, my lord, the post has been advertised as because Vipul Chandra Das, he retired on 31/12/22. Now I'd like to draw your lordship attention to page, page number 18 of my requisition.
Yes, I'm there.
Vipul Chandra Das, their roster point is shown to be 2. He retired, but he was, although he was belong to SC category, but he was appointed as unreserved. So if the person in roster point number 2 retired, then the first replacement according to me is unreserved.
my lord, that is a
No,
factual
can't be,
inaccuracy, my lord.
because that can't be. If the post is earmarked against the particular roster point, then even if Vipul Chandra Das was a incorrect candidate, it wouldn't change the roster point.
Earlier, my lord, the system of the roster was slightly different from what my learned friend has annexed on it. Because they have in their annexure, they have mentioned that roster point number 5 belongs to
This
STP.
this post of library bearer which cadre? Junior assistant or
No, my
grade
lord,
4?
grade four.
Grade 4. Grade 4.
Grade. My lord, and Bipul Chandra Das is not roster point number 2. What my learned friend is referring to, my lord, is the column heading of that table. His roster is unreserved, my lord. My learned friend is referring to the column heading, not the roster.
So if it is unreserved, in page 41, where he will be there?
My lord, roster point number 1. I have explained, my lord, because in my other affidavit from starting from page 67, I have an XY, my lord. Because earlier
Page.
from page 67, my lord, my affidavit filed on 9th of April 24.
Yes.
My lord, earlier the roster was not maintained in the college because it was in the prior to provincialization. It was only after provincialization, my lord, that the roster they were fitted against particular roster points. And Bipul Chandra Das, since he was the senior most person, he was adjusted against roster point number 1. My lord, at page 71, my lord, from A, B, C, D, how they were assigned roster points, that I have explained, my lord. Page 71, sub A.
71, no, there's something wrong. Your affidavit in opposition.
Yes, my lord.
Additional affidavit.
Additional affidavit in operation, my lord.
Ah.
It starts at page 67. Filed
It
on
is
9th of
60.
April. Typed, the type page number is 71.
61.
61. 61 is most probably the previous affidavit.
61 is an affidavit.
61 is the previous affidavit. After
7 to
that.
2024.
Yes, my lord. That is after, not that affidavit. In that affidavit, I have mentioned about the overage.
Yes.
Thereafter, another affidavit is there, my lord. Starts at page 67, my lord. Running page 67.
67 has become 71 now.
Oh,
Yes.
I'm so sorry, my lord.
No, it's okay.
My lord.
Now here, which page?
My lord, here it will be para, my lord, 7.
Paragraph 7, yes.
My lord. Paragraph 7, and the next page, my lord. Accordingly, the roster register, just after the reservation roster points in the middle of the page, lordship finds that.
That it was the first time.
It was after receipt of the said
Yes,
letters.
yes. Para 7.
Para 7. If my lord turns the page, in the middle, I have mentioned about the roster reservation roster points. Thereafter, starting with accordingly.
Yes.
Accordingly, the roster register of grade 4 staff of the college was prepared in the following manner. A. Bipul Chandra Das, the senior most grade 4 staff, a scheduled caste category employee, was placed in the first roster point, which was unreserved, as there was no unreserved category person amongst the grade 4 staff of the college, and there was no roster point for scheduled caste in the initial recruitment of cadre strength of 5 posts for cadres having 13 posts or less. Then B. Rudra Kumar Nath, the second senior most grade 4 staff, a person belonging to an OBC, was placed against roster point number 2, which was reserved for OBC. C. Prahanta Kumar, the third senior most grade 4 staff, a person belonging to the scheduled tribe plains, was placed against roster point 3, which was unreserved as there was no unreserved category. Then D. Robin Deoraja, fourth senior most category grade 4 staff, person belonging to scheduled tribe plains, was placed against roster point number 5, which was reserved for scheduled tribe plains category. E. Ahom Das, fifth senior most grade 4 staff belonging to the scheduled class, was placed at roster point number 4, which was unreserved. There are no unreserved persons in that in grade 4 in the college. So therefore, this was sent for approval to the directorate, or it was approved. And now this on retirement of Bipul Chandra Das, another next vacancy has arisen, which is number 6, madam, which is for OBC. This was approved by the directorate. The 100-point roster also, my lord, is at page 81. Point roster from page 81, my lord, it is for OBC, MOBC.
So roster point 6
ma'am.
is for OBC, MOBC.
OBC and MOBC. We have advertised for OBC.
Sorry, Mr. Chaudhary, we can't help you.
Sorry.
Third. So I already done it. Counsel for the petitioner. For higher education will be there. From Mr. D. Upamanyan and standing counsel for the higher education department. Representing respondent number 1 and 2. And Mr. P.D. Nair and counsel for respondent number 3. For OBC, the plain tribes, you're there, your name? A? Long-termer. You can please write your spelling. Done it. Counsel. Standing counsel for the respondent number 4. Next one. In brief, the petitioner, the case of the petitioner is that he has the requisite qualification and belongs to the SC category. Full stop. He was initially appointed as a temporarily as a library bearer in Roha College at Nagaon on contractual basis on 17/9/2016. And since then, he's serving this at college. Full stop. One, Bipul Chandra Das, who was serving as the library bearer in the said college, had superannuated on 31/12/2022 full stop. Accordingly, advertisement was published on 8/2/2023 for filling up the post of library bearer. Full stop. However, the advertisement indicated that the post was reserved for OBC/MOBC. Full stop. Accordingly, the respondent authorities did not accept the application submitted by the petitioner. Full stop. Accordingly, by filing this petition under Article 226 of the Constitution of India, the petitioner has prayed for setting aside the advertisement dated 8/2/2023 in respect of the post of library bearer at Roha College. To set aside the selection public recruitment process and for a direction to the respondent authorities to appoint the petitioner. No, not to appoint the petitioner, to fill up the post of library bearer as per the terms of the Assam Scheduled Castes and Scheduled Tribes within bracket reservation of posts in services bracket closed Act 1978. Reservation of post or reservation of posts? S.
Posts, yes, approved.
Yes. Okay. With a further prayer, we direct the respondent authorities not to hold the interview and conclude the process. Next one. The learned counsel for the petitioner has submitted that that Vipul Chandra Das, who had superannuated as library bearer, though belonged to scheduled caste category, was appointed in the unreserved category. Full stop. Accordingly, it is submitted that as per the roster point, for a replacement recruitment, the resultant vacant post should be reserved for scheduled caste community. Accordingly, it is submitted that the respondent number 3, the authorities of respondent number 3 intend to appoint persons of their own choice, and therefore they are proceeding with the advertisement, which is illegal, and that the post cannot be reserved for OBC or MOBC. Full stop. It is also submitted that the respondent authorities are wrongly interpreting the provisions for reservation and that the post of library bearer ought to be filled up only with a scheduled caste category candidate and not OBC or MOBC category. Yes, anything more? Anything I have left out? Sorry. Next one. Per contract, the learned counsel for respondent number 3 has submitted that the petitioner is disentitled for applying for the post of library bearer of Roha College, inter alia, on 3 grounds. Number 1, being number 1, that the vacancy is earmarked for OBC category candidate, And therefore, the petitioner being a candidate belonging to SC category is not entitled to apply or for being appointed. Secondly, it is submitted that the petitioner has surpassed the maximum age for a recruitment to the post of library bearer and the and the and therefore the petitioner is otherwise disentitled for even for a relaxation of the maximum age for such recruitment. Thirdly, it is submitted that when Vipul Chandra Das thirdly, it is submitted that that Roha College was initially a venture institution, and they said college was provincialized when provincial is the year and subsequently the college was provincialized.
My lord, 2007, my lord.
2007. Post op. At that time, Vipul Chandra Das was the senior most grade 4 staff, and though he was a scheduled caste category employee, he was placed in the first roster point, which was for unreserved category. As there was no unreserved category person amongst the then existing grade 4 staff. It is further submitted in the said context that the cadre strength of grade 4 staff in the said college is 5. And accordingly, the 5 then existing grade 4 staff were placed in the five roster points in the following manner. Vacillate. A. Vipul Chandra Das in roster point number 1 as unreserved category, Rudra Kantanath was placed at roster point number 2, which was reserved for OBC category. C. Prasanta Kumar, the third senior most grade 4 staff who belongs to scheduled tribe within Plains, was placed against roster point number 3 as an unreserved category. The unreserved category is 2.
Sorry, ma'am.
Unreserved category.
My lord.
There are 2 people.
2 unreserved.
roster points number 1, 3, and 4. Oh, sorry, yes. No, but then you are writing in your affidavit that there was no unreserved category candidate.
There is no unreserved. The persons belonging to the reserved categories.
Oh,
they
acha,
were-
acha. Okay. Was the scheduled claims category was placed at roster point number 3, which was also for unreserved category. As there was no unreserved category person amongst the grade 4 staff, then grade 4 staff. Robin, RABIN, Robin Devaraja, DEW, both cinemas grade 4 staff belong to scheduled tribe within bracket plains category was placed at roster point number 5, which was reserved for ST within bracket P category, and Sri Assam ASOM Das, the 5th cinemas grade 4 staff belonging to scheduled caste category was placed at roster point number 4, which was for unreserved category, as there was no unreserved category staff amongst the then existing grade 4 staff. Next paragraph. In continuation to the third point referred above, it is further submitted that the roster register was thereafter sent to the Directorate of Higher Education from Assam for approval. And accordingly, the approval was granted by the WPT and BC department by the endorsement dated 2/5/2019, which was intimated to the Director of Higher Education by communication dated 16/5/2019. Accordingly, comment is submitted that in light of the roster register, the recruitment for the replacement of library bearer with on direct recruitment is in accordance with law, as the replacement can only be of an OBC or public MOBC category candidate under roster point number 6. Next one. Consider the submissions made at the bar and also consider all the documents available in the pleadings and documents on record. First up. The the response number 3 in its affidavit in opposition filed on 28/11/2023 has annexed the office copy of the office memorandum dated 4/11/2013, which indicates the 13-point roster, which indicates that the roster point number 2, 6, and 10 would be 2, 6, and 10 respectively. And accordingly, for the direct recruitment or replacement category, the post would be available only for roster point number 6 under OBC or the MOBC category. Is it OBC or MOBC? MOBC is not written here in page
MOBC
41.
is not there, but later on they have put in, my lord. But in the 100-point roster, it is put as OBC, MOBC.
100-point is OBC.
OBC, MOBC. 13-point is
It's OBC under 13-point roster, which is subsequently made available for OBC/MOBC under roster point number 6 under the 100-point roster. Where is that 100-point roster?
On page 81.
81.
In fact, this 81 is a better copy, including the one which Lordship was reading, my lord. My lord, at page 38. This is not so good a copy, my lord. Page 38 and 81 will be 84. Both same document, my lord.
Okay. Okay.
Page 84 is a better copy.
It's okay. Once. Next paragraph. Therefore, as the petitioner belongs to an SC category, no, according the court is of the considered opinion that the post of library bearer, which was advertised for recruitment, would be a vacancy available under the roster point number 6, which is earmarked for OBC/MOBC category. Stop. Therefore, as the petitioner belongs to SC category, is disentitled for being selected or appointment for the post reserved for OBC/MOBC. Full stop. Next, moreover, as it is not in dispute that the petitioner has crossed the maximum age for recruitment, and there is no application pending before the competent authority for relaxation of age, the petitioner is otherwise ineligible for applying for the said post of library bearer at Roha College, Roha. Next paragraph. Accordingly, this reputation fails and the same is dismissed. There should be no orders to cast. Right.
The interim order, my lord.
Okay, interim order passed and it stands vacated. I'm jumping to this service law after foreigners tribunal. Is everything right?
Yes, my lord,
Okay.
perfectly right. Deeply obliged, my lord.
Very difficult to unwind. That's why I'm asking you a question.
But the basic.
Time being item 26.
Deeply.
Application fine, this time the correct application has come. My lord, I have not applied for the, let it come on 4th, my lord, I will obtain instruction.
Thank you, sir. Okay, come.
What the proper form? There also, my lord, he has mentioned as general.
Let it come on 4th, I will obtain.
It's okay,
instruction.
it is not disputing it. No, it's okay. You don't need it, you take your word for it.
I have given him a copy in the WhatsApp.
It's okay, he has accepted it.
Instruction. They're on 4th, my lord.
When he's there, when Mr. Roy Chaudhary is there, I don't have to worry.
A fact cannot be disputed.
No, not that.
Admitted fact, my lord, need not be proved.
No, we don't know. But the only statement I can give is that when you are there, I am at least you don't have to worry. Had Mr. P.K. Rajati done counsel for the petitioner. There's a part dictation given. No? Can this be dictation too? The dictation given. As well as Mr. B. Gogoi, and standing also for the health department. Next, the learned counsel for the petitioner has submitted that the matter relates to medical admission of the petitioner, and therefore he expresses some urgency in the matter. It is submitted that the counseling process is extended by the competent authorities till 5/11/2024. It is extended till 5.
No, not counseling, my lord. The last date of admission is 5th.
Admission, okay.
November.
Admission is
5th of November.
5th of November 2024. Next paragraph. The learned standing counsel for the health education, medical education department submits that he is in the process of getting the appropriate instructions and would address the court on 4/11/2024. Next, accordingly, the matter stands adjourned today. Next para. This is the matter on 4/11/2024 in the motion column.
Lordship, one thing, my lordship, I recorded that whatever instruction I have got, I have communicated to the petitioner. At least, my lord, the
I see.
petitioner will reply.
Obtain
Okay,
instruction.
yes, because regarding the form.
Has obtained certain instructions and has shared
furnished it.
it with the learned counsel for the petitioner.
And we'll option the instruction to them.
Accordingly, both sides pray for further time to obtain instructions. Next paragraph, this is the matter in the motion column on 4/11/2024. Medical education. That you put here in the listing. Okay. I think you are married now. Yes.
Time being item 13.
Yes.
What's it, if possible, one last more chance, Lordship. Otherwise, it has to be passed.
Because this 2017 onwards,
Lordship.
if you don't file. 17 is how many years now? 17, 7 years. I think I was wrong in my mathematics. 10 into 7 is 70,000. Okay. No, cost we are imposing 50,000.
Otherwise, your lordship will pass the necessary
Hmm?
order. Otherwise, your lordship will pass the necessary order.
Okay. Heard Mr.
A Gohain.
A. Gohai, learned counsel for the petitioner. Also heard Mr. P.N. Goswami, learned
PN Sharma.
P.N. Sharma, sorry, learned standing counsel for the Elementary Education Department, representing respondent numbers
Respondent number 1, 1, 3, 1, 4, 6, 7.
1467. As well as Mr. N. Goswami, learned government advocate appearing for respondent number.
D. Bhattacharya.
Oh, D. Bhattacharya, I'm sorry.
Standing counsel age. Responding 3.
Respondent number 3.
3.
Okay. And standing counsel for respondent number 3. And Mr. H. Alial, and it's standing counsel for respondent number 2.
2 and 8.
2 and 8. Next one. At the outset, it may be mentioned that the learned standing counsel for the Elementary Education Department has prayed for an adjournment so as to file the affidavit in opposition by the Director of Elementary Education, it is by producing a draft copy of the affidavit in opposition. It is submitted that the draft is available with him, but it could not be filed in the appropriate time. Full stop. Next paragraph. In this case, the husband of the petitioner had died on 28/8/2013 and claiming release of arrear salary and other pensionary benefits. This writ petition was filed on 17/3/2017 and rule was issued by order dated 22/3/2017. Full stop. By an order dated 15/11/2017, 2 weeks was granted as a last opportunity to file an affidavit. Full stop. Thereafter, at the instance of the standing counsel for the Elementary Education Department, matter was adjourned on 18/4/2018, 14/5/2018.
Also, in the earlier occasion, there was an affidavit filed. In 2017, there was an affidavit filed by the department.
No, my lord.
In 2017, perhaps there is an affidavit.
No affidavit has been filed. My lord.
The new affidavit.
No, my lord.
We don't have it here. If it was filed, we don't know. There's not filed. At least the court doesn't say so. There's one affidavit by respondent number 3.
Yes, my lord.
There's no other affidavit. On 8/6/2018.
Respondent number 3. Sorry.
18/7/2018. 14/6/2024. 17/7/2024, five eight 2024, on which it was made clear that no further time shall be given, by further providing that the writ petition shall be disposed of on the basis of material available on record, if no affidavit is filed. Full stop. Notwithstanding the said order, the matter was again adjourned at the instance of the Standing Council for the Elementary Education Department on 27/8/2024. And 5/9/2024 and 19/9/2024. So it may be mentioned that even by order dated 5/9/2024, the prayer for adjournment was allowed as a last chance. Full stop. Therefore, on a prayer for adjournment made, the court had asked the learned Standing Council for the Elementary Education Department to obtain instructions as to whether the said department, the Elementary Education Department is prepared to pay an adjournment cost of rupees 50,000. Full stop. To the said court query, the learned Standing Council for the Elementary Education Department obtained instructions from the authorities, and on refusal to pay such costs, the court is inclined to hear the matter on the basis of materials available on record by refusing adjournment, any further adjournment. Next para. In brief, the case of the petitioner is that her husband, namely Budhindra, Budhindra Datta, was appointed as assistant teacher in Bordoloni, Bordoloni, Borua Pathar, Baruapathar, Lower Primary School, Dhemaji, in the year 1989, under the Deputy Inspector of Schools, Dhemaji. Full stop. It is projected that though his service was regularized and confirmed, the salary of her husband was stopped from August 2007. Full stop. Accordingly, the husband of the petitioner, along with others, approached this court by filing WPC 5635 of 2007, and this court, by an order dated 27/4/2012, disposed of the writ petition by directing the Director of Elementary Education, Assam, to examine the cases of the petitioners. Full stop. The said authority, by an order dated 5/5/2015, rejected the claim of the petitioners. Stop. It is submitted by the learned counsel for the petitioner that one of such assistant teacher had approached the Supreme Court of India by way of a may approach this court by filing WPC. One of such administrative person, namely Dulu Devi, DULU DEVI, had approached this court by filing WPC 2560 of 2017, which was dismissed and thereafter the dismissal order dated 6/4/2010 passed by this court was assailed by the said Dulu Devi, DULU Dulu Devi, by filing special leave petition before the Supreme Court of India, which was registered as SLP within bracket C number 19947 of 2010, which was allowed by judgment and order dated 9/10/2015. By holding that the said applicant is entitled to continue in service and was further entitled to all arrears of salary in accordance with law. Full stop. In the meanwhile, the husband of the petitioner had died in harness on 28/8/2013, and therefore the petitioner has filed the present writ petition under Article 226 of the Constitution of India to assail the impugned order dated 5/5/2015 passed by the Director of Elementary Education Assam, and further seeking all arrears salary and other pensionary benefits. Next paragraph. As indicated above, as no affidavit in opposition has been filed for about 7.5 years, 1/2 years. There is no material on record to show that the service of the petitioner's husband was terminated as indicated in the impugned order dated 5/5/2015. By the Director of Elementary Education Assam. To stop. Not only it is incumbent for the competent authority to pass an order of termination of service, but it is equally incumbent on their part to serve such termination order to the person whose service is terminated. Full stop. The court is unable to presume that the service of the petitioner was, the husband of the petitioner was terminated in the absence of any document being brought on record. Next paragraph. From the, be that as it may, from the submissions made by the learned standing counsel for the Elementary Education Department, the case sought to be projected by him is to the extent that is that there were large scale illegal appointments appointments of teachers by several officers in the elementary education department, and several of such appointments were also made in the district of Dhanaji. Full stop. How many were there? 900 something? How many teachers were appointed? How many?
Teachers, Lordship.
Huh?
They have alleged, my lord, 725 numbers of.
No, there's more.
Around 9,000 some teachers were illegal appointments.
Where is that? Where will you find it?
Exact amount, exact number, Lordship.
It's not here.
At the moment.
Okay, it says almost more than 9,000 such illegal
Lordship,
appointments were
9,000.
made. And made in the state of Assam. And in Dhemaji district, how many were there?
725.
And in Dhemaji district alone, 725 illegal such appointments were made.
752, Lordship.
52. Okay,
Lordship,
752 appointments were made.
Yes, 42.
Okay. Where is that 15-5 order?
15.5 order is at
Page
page
44.
44.
5, page 44.
44.
Next, on the perusal of the impugn order dated 5/5/2015. It is noted that there's nothing in the said order to indicate that any action was taken against the husband of the petitioner, namely, what is the name? Budhindra.
Budhindra Datta.
Budhindra Datta. Budhindra Datta. And the manner in which the proceedings was initiated. Full stop. The said order also does not contain any statement that due notices were served on the petitioner and the proper procedure as prescribed under the provisions of the Assam Discipline, Assam within bracket Discipline and Appeal bracket close rules of 1964 was followed. Also, there's also no statement made therein that the termination order was served on the husband of the petitioner. Full stop. There were 44 writ petitioners in WBC 5635 of 2007. And it is, and in the order dated 27/4/2012, passed in WBC 5635 of 2007, it has been recorded that the petitioners claim, that the petitioners therein claim that they were never served with any termination order. And accordingly, after discussion of the matter, the court had remitted the matter back to the authorities by directing the authorities to examine case of each and every petitioner as to whether they had been served with show cause notice for termination or the termination orders. And if it is found that no show cause notice or termination orders had been served to them, they will be entitled to get salary for services rendered by them as given to them for the period of December 1989 to May 1992. Full stop. Despite such specific directions contained in the aforesaid order dated 27/4/2012, the impugn order under memo number EHA, full stop 410/2007 /631, dated 5/5/2015, lacks determination with regard to the present petitioner. Next paragraph. Therefore, in the absence of any finding recorded in the said impugn order dated 5/5/2015 as to whether the husband of the petitioner was served with a show cause notice or a termination order, by the vague contents of the said order dated 5/5/2015, it cannot be presumed that the petitioner was served with either a show cause notice or the husband of the petitioner was served with a show cause notice or with a copy of the termination order. Next para, accordingly, the court is of the considered opinion that by withholding filing of the affidavit in opposition for more than 7.5 years, this is a fit and proper case to invoke the doctrine of non-traverse and to hold that the respondents have respondent numbers 1, 2, and 3 to 1, 2, and 4 to 8
4, 6, 7,
have admitted the claim of the petitioner. Next para. Resultantly, this represents allowed on admission, and the said impugn order dated number EHA full stop 410/2007 /631, dated 5/5/2015, issued by the Director of Elementary Education, Assam, is set aside insofar as the husband of the petitioner, namely late Budhinder Datta, is concerned. And this order should be read only qua the deceased husband of the petitioner. Full stop. Resultantly, the Director of Elementary Education, Assam. Now it is school education.
Department of School Education.
Now,
The director is the Elementary Education Department.
Okay.
Secretary, Department of School Education.
Okay. Elementary Education Department under the administrative control of the School Education Department is now directed to take steps as may be required for releasing the pensionary benefits, including death cum retirement gratuity, group insurance savings, provident fund, leave encashment benefit, etc., as may be as would have been entitled to late Budindra Dato, and thereafter to the petitioner, namely Srimati Reena Fukan Datta, on the death of her husband. Full stop. The said benefit, financial benefit, should be made available to the petitioner within the outer period of 6 months from the date of service of a certified copy of this order on the Director of Elementary Education, Assam. Full stop. Next, but on failure to make payment within the time allowed, the petitioner shall also be entitled to a token interest at the rate of 4% per annum from the expiry of 6 months from the date of this order till recovery. Next, persistence allowed to the extent as indicated above. Next, under the circumstances, we leave the parties to bear their own cost.
My lord, arrear salary from August 2007.
They have not made the prayer. You'll have to amend your
Yeah, my lord.
petition then.
This is prayer, my lord. Last, my lord.
Where
13, page number 13, last, my lord. And or a writ of nature of mandamus should directing the respondent to release the arrear salary of the petitioner from August 2007 to 28/8/2013.
and or means is an alternative prayer.
Last portion, my lord, page number 13, my lord.
Okay, you had there. Retirement benefit period salary of the petitioner's husband for the period from August 2007. No, but then you have to tell us why August 2007, when your husband did not claim. Your husband died when?
2013, my lord. We have, I have petitioner has been already filed, my lord, WPC 5635, my lord.
5635 is already disposed of.
Dispose of, my lord. Thereafter, thereafter I have filed, my lord, along with arrears salary, my lord. This petition is for
for the period from August 2007 to 28/8/2013, if payment for the said period is not already released to the deceased husband of the petitioner. Yes, you wanted to say something?
He has filed an affidavit, that way we mentioned.
I have already recorded. 3. What's
That's
right somewhere the standing counsel for the Accountant General, Assam, has also made his submissions and has referred to the affidavit in opposition filed by respondent 3. Okay.